Hello. I got to add me to the stage where I can just start talking. You know how that works. I hope everybody's doing well. Let me just stick myself here in the middle. Hi, guys. Yeah, so today we are going to we're going to throw back a little bit. There was a sentencing about 3 weeks ago, and before I took over this channel, I was doing trials on my own, and one of the first trials I did was a resentencing hearing over some death penalty changes in the state of Florida. It was the Xbox murders from 2004. Good afternoon, Cindy. How are you? Hi, Iowa. Thank you for being here. And I seen TCN was here. Journey popped in. I'm so glad everybody's here. So what we're going to do is, because a lot of my stream from back then, y'all weren't around when a lot of the people here aren't aware of what I did over there. So I'm going to give a brief recap. I know, woof, woof, these things are playing back here. Girl, Journey, real quick, as a funny, I want to show something really quick. Do you remember yesterday when your dog was barking in the background? Yes, your dog was barking in the background during stream. This is what happened. My dogs came straight up to me and was all up in my business trying to see what was going on with my phone, because my phone had little barks coming out of it. So that was my meat and Lola up there in my business trying to figure out where that dog bark was coming from. So bless their little hearts. Them are my babies. So we're going to start off here. Actually, what I'm going to do is we're going to back up a little bit, and I'm going to play well, let me see. This is okay. This gives a little bit of background, and then we'll do I'll play just the beginning of my stream, which kind of gives a little more in-depth from that I had streamed previously when we originally did it. So I'll be quiet because I'll be narrating on that stream. So, but we're going to go into watch this first. This kind of gives a basic overrun of what the trial was about for those that do not know, was not around. So I just want to give that. Yes, partners in crime, they are my babies.
If you've experienced the water damage in your home or business, I think Frontier is the best option.
And the resentencing hearing for 2 men convicted of killing 6 people over an Xbox is scheduled to start tomorrow. Troy Victorino and Jerone Hunter were convicted in 2006 and sentenced to death. The Florida Supreme Court overturning that sentence because the jury was not unanimous on the death sentence. Then a state law was passed in 2023 saying juries did not need to be unanimous. Only 8 jurors out of 12 need to vote for death.
So that was what the problem was. So we can read over this real quick, just a little bit. 2 men who murdered 6 people over an Xbox appeared in court on Friday as lawyers filed motions.
You probably know Vistaprint for business cards because we printed them for millions of small businesses.
Hush, commercial. As lawyers filed motions for the resentencing trial, opening statements on the resentencing trial of Troy Victorino and Jerone Hunter are set to begin Monday morning. Backstory. In 2004, Troy Victorino and Jerone Hunter joined 2 other men in the killing of 6 roommates and a dog inside a Deltona, Florida home. In 2008, Victorino, Hunter, and the 2 other men, Michael Salas and Robert Canone, were also, I'm not sure if it's Canone or Cannon, were all convicted in what's been dubbed as the Xbox murders. Prosecutors argued the motive behind the home invasion and brutal murders was to retrieve an Xbox that claimed to have been stolen. Salas and Canone were sentenced to life in prison, and Victorino, the ringleader, and Hunter were sentenced to death in the 2004 slayings. In 2017, Victorino and Hunter's sentences were overturned due to a ruling by the Florida Supreme Court. The ruling changed state laws, which now stated that Florida's death penalty had to be unanimous. Victorino and Hunter's sentences were not unanimous at the time. The new law allowed anyone sentenced after 2002 ruling eligible for a new sentence. Since they were sentenced in 2004, they were eligible to have this new sentencing trial. So in 2023, their initial resentencing trial was halted due to a motion request. The judge abided by the newest death penalty laws that went in by DeSantis. And they stated that all death penalties must be carried out with an 8-4 jury vote. So it didn't have to be unanimous anymore. It didn't have to be all 12. So with that, they decided to retry these people. So I will, I'm going to share this. I'm going to play a little bit of this. This was my original stream. Yes, it did. It changed because of a case that had happened. And right. But let's get to this. And y'all, please bear with me. Please understand too that this was one of my original, very first trial I ever did. So I didn't know what I was doing, to be exact, but I did the best I could. This was 3 months ago when I had done, I just did lives before, but I'd never done a trial. This was the actual first trial that I endeavored upon and tried to do. And I think I did it successfully and I really enjoyed it. So anyways, let's roll with this for a minute. And I kind of give you the backstory, and then it is the opening to the resentencing trial. We'll listen to that and then we'll roll over. We are looking at this is the Xbox resentencing. So just to kind of go over this real quick, let's see here. It's a resentencing. And I'm going to give y'all a real quick rundown. They don't get a new trial. These two men are out of Orlando, Florida. They will not get a new trial. They didn't get a new trial, Cindy. They were heard for a new sentence because of the law changes of the death penalty did not have to be unanimous anymore. It had to be an 8-4 vote instead of a unanimous vote. They murdered. I'm using my words because I'm not monetized. I don't care to be monetized. It's nothing right now in my near future. So I'm going to use the words. I'm going to read it as it states. It says the two men were murdered 6 people over an Xbox. They appeared in court and they filed a motion for the resentencing trial. So today they did their opening statements for the resentencings. It's Troy Victorino and Jerone Hunter. And the backstory is that in 2004, Troy and Jerome joined 2 other men in the red room of 6 roommates and a dog inside a home in Deltona, Florida. In 2008, Victorino and Hunter and the 2 other men, Michael Salas and Robert Canone, they were all convicted of what's been called the Xbox murder. The motive originally was argued that it was behind the home invasion and brutal murders was to retrieve an Xbox that it claimed had been stolen. Salas and Canone were sentenced to life in prison, and Victorino, the ringleader, and Hunter were sentenced to death for the 2004 slayings. But the sentences were overturned by a ruling in the Florida Supreme Court where Florida changed the state law. It's now stated that Florida's death penalty had to be unanimous. Victorino and Hunter's sentences were not unanimous, and the new law allowed anyone sentenced after the 2002 ruling to be eligible for a new sentence. So this is where we are at. This is where we are at. It's not illegal to say that word. Okay, go. 420. We started the stream at 420. Let's blaze it up. So, oh God, y'all, I'm so sorry. Oh my Lord, I don't even remember doing that. Jesus Christ. Woo, going back and watching some old streams is kind of freaky. That's the basic of this Xbox murder trial. And hi, I'm here. Hi, I'm here. Nice to meet you. And hi, this is Hio. So let's get this thing started. We're going to start out with opening arguments. Let's go.
Good morning. It is my solemn responsibility this morning to now tell you what evidence will be presented to you about the events of August 5th and 6th, almost 21 years ago in 2004. I must caution you now and acknowledge my linguistic limitations. No matter how detailed I am, no matter what vocabulary I use, My words will not adequately describe and prepare you for what you will see, what you will hear, and what you will learn about August 5th and August 6th of 2004 in the city of Deltona. On that date, inside a home at 3106 Telford Lane, the sound of metal bats striking human flesh and shattering human bone rang out over and over and over again. These repeated swings and impacts left walls splattered and carpets soaked in blood. The blood of 6 young people whose lives were taken that night by the action of the 2 men sitting behind me. And remember, these 2 men who sit before you now have already been convicted beyond every reasonable doubt of murdering these 6 young people. The evidence that will be presented by the state of Florida in this case will prove multiple aggravating factors that will greatly outweigh the mitigating circumstances we expect that the defense will present to you, aggravating factors warranting only one sentence under the law, a sentence of death. Now, before describing some of the evidence to you, I want to talk to you, and talking about the aggravating factors, I want to talk to you about some names that you will hear in this case. One, you will hear the name Robert Cannon, or the names Robert Cannon and Michael Salas. Cannon and Salas are co-defendants of Victorino and Hunter. They also entered the home in Telford Lane in August of 2004, and they are also charged and convicted of first-degree murders. The second group of names I want to talk to you about is the victims in this case, and the names you will hear, and some of the findings made by the medical examiner back in 2004. The first person is Anthony Vega. Anthony Vega was 34 years old when he was murdered on August 5th, late August 5th and early August 6th of 2004. Mr. Vega, cause of death was blunt force trauma to the head. Like all the victims, the cause of death was blunt force trauma to the head. He suffered 5 to 6 blows to the front of his head, 2 blows to the back of his head, fractures to his face and his skull. He actually had a depressed skull fracture. His face from the blows was caved in. He had perimortem stab wounds to the neck. Perimortem means that the stab wounds happened while he was still living, as opposed to postmortem, which means an injury happened after the person was deceased. And like almost all the victims, he also had defensive wounds to his body, to his hands and his arms. You're going to hear about Roberto Gonzalez, who was 28 back in August of 2004 when he was murdered. As I said before, the cause of death, blunt force trauma to the head. The blows, bless you, to Mr. Gonzalez, came to the front of his head. He had at least 10 blows inflicted to the front of his head. He had multiple skull and facial fractures. These fractures were so severe, you will hear, that a saw.
Please be aware that this is a very, very brutal murder. These 4 men went in and took out the Erin Belanger, Michelle Nathan, Robert Tito Gonzalez, Jonathan Gleason, Francisco Flaco Romano, and Anthony Vega. They went in and took out these 3 people and their dog with a baseball bat. Okay, that's the brutality of this. A baseball bat
Was not needed at autopsy during the examination. He had brain lacerations. He had brain hemorrhaging. He had multiple stab wounds, and the stab wounds were to his chest, and they were both perimortem, meaning before.
Yes, and they were using a knife also, but most of it was done with a baseball bat.
He passed away, was deceased, and postmortem, meaning after he had stopped living. And he also had defensive wounds to his hands and his arms. You're going to hear about both Erin Belanger, age 22, and Francisco Roman, age 30. They were a couple. Both the cause of death was blunt force trauma. Mr. Roman had depressed skull fractures, or a depressed skull fracture. He had significant impact to his head. It was so significant that his ear was torn off by the impact. He had stab wounds to the chest and neck, and he also had defensive wounds. For Ms. Belanger, she had at least 3 large impacts to her forehead and additional smaller impacts to her face. She had a significant impact. The skull was fractured and driven into her brain by the blow. She had a stab wound to her chest and neck, and she also had defensive wounds to her hands. The next victim, Jonathan Gleason, was only 17 years old in August of 2004. His cause of death, blunt force trauma to the head. He suffered 7 to 8 blows to the chest, head, and neck. He had a depressed skull fracture. He had post-mortem stab wounds to his chest. Remember post-mortem after?
Post-mortem, meaning he was already deceased from all the blows of the baseball bat, and then they went ahead and stabbed him some more while he was already gone. Great people.
He was no longer living. He had perimortem stab wounds to his abdomen. And he, like the other victims, had defensive wounds on his hands and his arms. And finally, Michelle Nathan, who was age 19 in August of 2004. Again, cause of death, blunt force trauma to the head. She suffered 6 to 7 blows to the back of her head, causing deep lacerations. She had displacement at the back of the skull, and she had stab wounds as well to her breast, her left side, her right hip, her ear, and her neck. And like the others, she had defensive wounds to her hands and her arm. Now, these 6 young people, you will learn, lost their lives because of some personal property. The property of the 2 defendants, Jerone Hunter and Troy Victorino. You learn that Troy Victorino had been living along with Mr. Hunter at a house owned by Erin Belanger's grandmother. And Victorino and Hunter had been kicked out of that house in July of 2004. And they believed that Erin had their personal belongings and they intended on getting them back no matter what the cost of doing so. And the cost ended up being 6 human lives. On July 31st of 2004, Victorino went to the Telford house saying he wanted to talk to Erin Belanger. Victorino was angry, he was threatening, and he was complaining that his stuff was missing. And he asked Erin that day if she had the property, his property. And he got upset when she didn't. Erin told Victorino that she would find it and get back to him. And Victorino said he would go to any means to get his property back from Erin. The very next day, on August 1st, 2004, Victorino, Hunter, the 2 other guys I mentioned, Salas and Cannon, and a man by the name of Brandon Graham and some other women, went to the house at Telford and had a confrontation with the people living there. While at the house, there's the verbal altercation. The women actually went inside the home and came out with some items. Tires were slashed, and the group left, at least for the time being, on August 1st, because a few days later, on August 5th, these 4 men again, Salas, Cannon, Victorino, Hunter, and Brandon Graham, who is a witness that you'll hear from probably today, were at the house that Victorino and Hunter were staying at, located on 4th Smith in Deltona. It was at the 4th Smith house that Victorino started talking about a movie named Wonderland, where a group of guys killed another group with lead pipes. And Victorino said to the other men that if he had a group, he would do that, like in Wonderland. And he said that he would do it at the house on Telford Lane. And the other 4 men, they were quickly on board. Salas said he was down. Cannon said he was ready to kill him a bitch. And Victorino said to Hunter, I know you were down because they took your shit too. And Hunter acknowledged, nodding his head in agreement. And from there, the planning became more complex and more detailed, with Victorino describing the layout of the house on Telford, including how many people were in the house and where they would be. And he said the men, their group, would split up and kill the people inside Telford once they made entry into the house. And during this conversation, Jerone Hunter actually suggested wearing masks to the group. But Victorino said that's not necessary because they weren't going to leave any evidence behind. They were going to kill every single person inside of Telford Lane. The group also discussed the process afterwards, saying they would probably have to change clothes. And during this conversation, Jerone Hunter told Brandon Graham the Hunter could give Graham a pair of clothes to change into after, because they're likely going to get blood on their clothing. And after this discussion at Fort Smith, the group left the house together. They left in a white Ford Expedition, and that belonged to Mr. Cannon. And during this time that they left the house, they were looking for ammunition for a firearm that they already had. And while away, they actually dropped Brandon Graham off, and you'll hear, like I said, from Mr. Graham. They dropped him off at one of Graham's friends' houses, and Mr. Graham absented himself after that. He didn't meet back up with those 4 men. He ignored calls and never went to the Telford Lane house later that night. You are going to hear details about what happened inside of Telford Lane once Salas, Cannon, Victorino, and Hunter showed up all armed with baseball bats. You'll hear how Troy Victorino kicked in the front door to the house after he had looked through the windows to see where people were. You're going to hear how Victorino immediately headed straight for the bedroom that Mr. Roman and Ms. Belanger, Erin Belanger, shared. You will hear how Jerone Hunter immediately began repeatedly beating Jonathan Gleason with a baseball bat as he sat on a chair in the living room. You'll hear how Roberto Gonzalez fought back against Salas after Salas found him in one of the bedrooms. But Hunter intervened and began to strike Gonzalez in the head over and over and over and over again. You'll hear that Salas and Cannon left the house first, before Victorino and Hunter went back to Cannon's expedition. But before Salas walked out the door, Victorino called him into Belanger's and Roman's bed, the couple that shared the bed. He went in and he wasn't sure when he saw Belanger and Roman if they were dead or just unconscious. He saw their bodies and he saw Victorino holding a taped up metal baseball bat. That was in one hand. In the other hand was Erin Belanger's leg, or her foot. And while he held her foot with her body halfway off the bed, he said to Salas, "Watch what I do to this bitch." Salas never saw because he left the bedroom after Troy Victorino said that. Hunter was the third to return to the expedition that was parked outside of the address at Telford Lane. And when Hunter arrived to the truck, he was excited. He began telling Salas that he found another one, a girl hiding in the closet of one of the bedrooms under a pile of clothing. He tells Salas how the girl, this was Michelle Nathan, the last victim that I showed you, 19 years old. He tells Salas how Michelle begged for her life after the event. And as she was begging for her life, Hunter told her, "Too late, bitch." And he stabbed her. And when she screamed, he beat her with a baseball bat. Repeat. Victorino is the last one to get out to the expedition. He's carrying a box full of stuff. The group begins driving away, but he quickly instructs them to go back. So they quickly return. Victorino goes back into the house. He retrieves some other items. He comes out with a plastic bag with bloody items inside of it. He directs them to a house in DeBerry, where they change their clothes, they wash off, and they end up disposing of these baseball bats. Now you will see in this trial, and I'm going to show you now, a map of the house at Telford Lane. It's a 3-bedroom house. And in this map, you can see each victim, victim 1, Jonathan Gleason, there on the recliner in the center room in the living room where the kitchen is located. Anthony Vega, just north of him on the map, victim 2. Roberto Gonzalez in the doorway of bedroom number 2 was victim 3. Michelle Nathan, this is the young woman who was in the closet. They are found just outside the closet, bedroom 1. Francisco Roman, victim 5, and Erin Belanger, victim 6, both located in that 3rd bedroom, bedroom number 3. Now in this case, the state will also present some of the investigators and experts who worked on this case back in 2004, 2005, and 2006. And the reason we'll present these witnesses is so that you can learn how investigators from the Volusia Sheriff's Office and the Florida Department of Law Enforcement were able to solve this case and then ultimately prove it beyond the exclusion of every reasonable doubt at a trial. You'll also hear about the autopsies of each victim. That testimony will come from the chief medical examiner for our area, Dr. James Fulcher. And finally, in this case, as the judge mentioned to you, and I want to go over them again quickly, is you'll hear about the aggravating factors in this case. So first, I want to talk about Jerone Hunter. As the judge said, will be your responsibility in this case to decide the appropriate sentence for 4 of the 6 victims: Jonathan Gleason, Roberto Gonzalez, Michelle Nathan, and Anthony Vega. So you will have a verdict form for each one of those victims for Jerone Hunter. The state is alleging 5 aggravating factors that the evidence will prove beyond a reasonable doubt against Jerone Hunter. 1, and these are shortened, the actual definition, the instructions will be longer. A conviction for a prior or contemporaneous capital felony. And you'll learn through the evidence and the law given to you by the judge that for each victim, the 5 other contemporaneous murders would satisfy this aggravating factor. Those count as prior or contemporaneous convictions for a capital felony. The capital felony was committed while the defendant was engaged in a burglary. You're going to learn that in this case, Jerone Hunter was also convicted by that prior jury of armed burglary for that aggravating factor. 3, the capital felony was committed for the purpose of avoiding or preventing a lawful arrest, also known as witness elimination. In this case, as I said, you will hear that testimony about prior to the homicide happening, the conversation that they would leave no evidence behind. There would be no witnesses, which is in fact what they did. They left evidence behind, but they left no witness alive in that house to make any type of identification or to say what happened. The capital felony was especially heinous, atrocious, or cruel. The judge gave you that definition, and you get that in your jury instructions. But I want you to pay close attention to the testimony of Dr. Fulcher, the chief medical examiner, and to the testimony about what happened inside of that home on Telford Lane when the 4 men entered. Because that is the testimony that will prove this aggravator, that these actions were especially heinous, atrocious, or cruel. And finally, the capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And that goes back to that conversation prior to the homicide, when it was planned out in such detail that they ensured the death of all the victims. And then you can look at the plan afterwards too, how they disposed of evidence so quickly and efficiently. Now, Troy Victorino, a little bit different. 4 victims, you'll have to decide the appropriate sentence for, 4 verdict forms. Erin Belanger, Francisco Roman, Jonathan Gleason, and Roberto Gonzalez. So for each victim, you will get a verdict form. Now, the aggravators are similar, but they are also slightly different for Mr. Victorino. There are 6 aggravators that the evidence will prove beyond a reasonable doubt. Here's the first slight difference. Conviction for prior or contemporaneous capital felony or violent felony. Same as Mr. Hunter, you've got the 5 other murders that would count as contemporaneous convictions for each victim you decide a verdict on. But you're going to learn Mr. Victorino was previously convicted of an aggravated battery, where he used a walking cane to beat a man in the man's head and his face, and beat him even after he was rendered unconscious. So you're going to have those contemporaneous felonies to consider, but you're also going to have evidence of this prior aggravated battery conviction involving Troy Victorino. The capital felony was committed while the defendant was engaged in a burglary, just like Mr. Hunter. Troy Victorino was convicted of armed burglary by a jury in this case. It was committed for the purpose of avoiding or preventing a lawful arrest. Again, witness elimination, as I already said. We talked about Jerone Hunter, his aggravators. The defendants, again, had that intent to leave no one alive and leave no evidence behind. The capital felony was especially heinous, atrocious, and cruel. We'll again ask you to look closely at the testimony and listen to the testimony of Dr. James Fulcher when you're making that determination. And then cold, calculated, and premeditated, same as Mr. Hunter. The state will present evidence about that plan of the group before they went to Telford Lane. And then one additional aggravator is that the capital felony was committed by a person on probation for a felony offense. And in this case, you will hear that Mr. Victorino was still on probation for that aggravated battery conviction that I mentioned for the first aggravated battery, the conviction for beating the man with the cane. So he was actively on probation in August of 2004. Ladies and gentlemen of the jury, this process is going to be hard for you over the next week and a half. The evidence that you will hear and you will see what 2 men are capable of doing to other people, it's going to be hard for you to digest. But you will see at the end that the evidence in this case justifies only one sentence under the laws of the state of Florida. Death. Death for each defendant. Death verdicts 4 times over for Jerone Hunter, for each and every victim on the 4 verdict forms that you received. Death for Troy Victorino, 4 times over on each and every verdict form for each and every victim you receive. Thank you.
Mr. Wood.
Judge, at this time, we defer our opening statement until the conclusion of the state's presentation.
You certainly may do so, Mr. Wood. Ms. Sammons.
Okay, so with that, they deferred their opening. They did it at the end, which was, it was a wild, crazy ride trial. So with all that, that just kind of gave you the rundown basics of the case. And so the people that did not watch the trial with me can actually know a little bit about what's going on and understand the death penalty hearing that we're going to watch. I do have another little news blurb. This was 3 months ago, and this just talks about that the jury recommendation after the trial. This is what came out. And they did recommend death. And then today is what we watched today was actually 3 weeks ago. With all these other trials I've been doing, I actually missed the hearing for the death penalty hearing for these 2 men. So let's watch this video real quick, and then we'll get into the hearing. It's only like 3 minutes, or not even 3. It's a minute and a half.
Also, some breaking news right now. Death sentence handed down by a jury in the Xbox murders resentencing trial.
That jury deliberated for about 7 hours today. Fox 35's Chris Lindsay is live outside the Volusia County Courthouse now. So, Chris, the jury thought both men deserved the death penalty.
Yes, both defense teams said their client would be better served serving life in prison as opposed to the death penalty. They focused on mental health issues and other traumas the two faced in their upbringing. It appears as though to the jury, the state had a much stronger case. After about 7 hours of deliberation, a jury has decided both Jerone Hunter and Troy Victorino, 2 killers convicted in the 2004 Deltona Xbox murders, will receive the death penalty. They each got at least 8 yes votes for each victim. This comes after several days of testimony from 3 separate legal teams. The state saying the violent home invasion in which Victorino, Hunter, and 2 others killed 6 people was cold, calculated, and egregious, among a few other aggravating factors.
We, the jury, find by a vote of 9-3, find that Jerone Hunter should be sentenced to death. We, the jury, find by a vote of 10-2, find that Troy Victorino should be sentenced to death.
Of all of the
Defense teams painted the picture of 2 men suffering from years of trauma, mental health issues, and substance abuse. Ultimately, the jury found the state proved all of the aggravating factors beyond a reasonable doubt. Reporting live in Volusia.
Okay, so the jury did find them guilty. So now this is the hearing. It says attorney. Okay, we're going to switch this tab. So this is what we will be watching today. Death penalty hearing in Florida Xbox murders. This was streamed live on July 25th, so it was about 3 weeks ago. Attorney for 2 men convicted in the so-called Xbox murders will be in court Friday for a last chance to potentially influence a judge before they could be sentenced to death. At a Spencer hearing, the defense for Troy Victorino and Jerone Hunter is expected to present additional evidence before the sentencing is imposed. So that is where we are. This does say it's like 3 hours, but there's like an hour break in here and stuff. So we will, as always, zoom. I have to stop and say that it's very comical to me to go back and watch myself, because I don't rewatch myself. I'm me, and I just never go back and rewatch myself. So it was kind of cute to see the little Katya, I'm here, and I'm like, hi, I'm here. I mean, that was really cute. And then I'm sitting up in that corner, like, I don't know. That's not how I do things now. I was still learning back then. So it's kind of funny to go back and look. So yeah, I was doing body cam videos for a month, and that was the first trial that I decided to embark upon and attempt to do it on my own. So that was this flashback's it's flashbacky for me. So anyways, let's get into this hearing and see what's going on with them. Let me know if I need to boost the sound. Of course, they're not talking right now, but
the bottom ones are fine.
We're going to Zoom because I don't know what we're waiting for. Troy, just wait if you can hear me. Can you wait if you can hear me? There we go. Okay, thank you. Oh, Troy's on video.
Huh?
Troy's not in the building.
You heard something.
There's Troy Victorino, guys. This is Troy Victorino. Yep, that be him. And welcome in, Norma. I don't believe I said properly. I did in chat, but thank you for being here, Norma. So I guess Jerone Hunter is actually sitting at the table in the courtroom.
What's got his snap like on? Y'all see that? It's on channel 2.
Okay, we can zoom through all this chitty chat, guys. Let's get to the hearing. I have no interest in this. Meat and potatoes, people. Meat and potatoes. Let's get there. Where's the judge? Bring the judge in. Let me see if I need to get down here a little bit and do this. The judge is still not here. Oh, here comes the judge. Hold up. All right, here we go. All right. Here we go. Judge is entering now. This is not the judge. This is not the judge. This is not the judge. There's the judge.
How old was that I made you? Sorry.
30. No, sixth grade. 30.
And I did have two motions to sever. One on, and let me just say it on the record, and we are on the record now. State of Florida versus Jerone Hunter, 2004 1380, and then of course we have State versus Victorino, and that is 2004 1378. I do have motions to.
I want to make sure y'all can hear because it's a little soft. It's only in one side. As far as my earphones, it's only coming in one side. So, and it's a little low for me, and I can turn up my volume, but I don't want to turn it up and blow all y'all's eardrums out. So is it loud enough for y'all?
Sever, and there have been motions to sever from the beginning of the case forward. Both motions are very well written. Do you want to add anything to what other than what you set forth in your motion, Mr. Wood?
Judge, I don't have any additional legal argument in there. Of course, emphasize the importance of where we're at right now with your honor going through the process of considering a life without possibility. So, no additional one.
All right, thank you. Ms. Sammons?
No additional argument.
All right, thank you very much. So I am going to very respectfully deny the respective motions to sever, and then we're going to move forward with the Spencer hearing. And counsel, how best would you like to proceed?
I can put on the record first, Your Honor, that the state does not intend to introduce any additional evidence at this time, and we will reserve most of our argument unless I have to rebut something today for the sentencing.
All right, thank you very much. Mr. Wood?
And we have on Zoom Dr. John DeSarni.
All right, and got it.
Dr. DeSarni, can you hear us okay? You're on mute.
Oh, and I just want to state for the record, we do have Mr. Hunter present in the courtroom, and Mr. Victorino is present by Zoom.
Yes, Your Honor, and I did verify that he can hear us and see us.
Thank you.
So he can, he's actually participating.
Thank you very much.
Dr. Cerny, can you hear me okay?
Yes, sir.
Okay. Would you state your name for the record, please?
Okay, comic relief here. Comic relief. Y'all know me. Comedy and the chaos. What in the hell is this hand thing on his screen right here? What is going on with this? I don't get it. I don't get it, but okay. I just, y'all know me and my squirrel moments.
Certainly, it's John Duzerney. That's Surrey.
Bless you.
And thank you, doctor. What do you do for a living, sir?
A clinical neuropsychologist.
And for yourself or for a company? Or?
For myself. I have my own practice.
All right. For the record, where's your practice located?
Florida.
And how long have you been well, first of all, are you licensed in the state of Florida as a neuropsychologist?
Subspecialty of neuropsychology is not an individual license. I'm licensed as a psychologist, as are all other neuropsychologists.
Okay. How long have you been practicing in the field of neuropsychology?
Approximately 20 years.
Okay. And can you provide the court with your educational background, please?
Yes, I received my undergraduate degree from College of Rutgers University. Then I took some master's level work at Resentencing University, and I received my master's in clinical psychology and my PhD in clinical psychology from Nova University.
Okay. And when was that last degree? When was that?
91.
Okay.
90 or 91. I have to, I'm sorry. It's been a while, so I forget. So, it was 91.
All right. And have you previously provided or given an opinion as an expert in neuropsychology on any prior occasion?
Yes, sir.
And when was that? Or how many? Well, when was that and how many times?
I've given opinions multiple times. I would have to go back and look beginning several years ago.
Okay. And for, I don't need specifics on each case, but generally, what types of cases were you providing expert testimony?
Either competency or competency to proceed, and then also occasional personal injury, and then also mitigation work.
Okay. Have you, in your expertise and prior work experience doing competency matters, was that in another state?
No, that's in Florida. Well, actually, let me correct that. Years and years and years ago, when I was in New York, I did testifying commitment hearings as part of my job as a psychologist at the county hospital.
And on those occasions in New York, were you retained or hired on behalf of the defense or the state or both?
The state, I was employed by the county, so I was representing the state.
Okay. And have you, prior to this case, provided expert opinion in any prior criminal case or capital murder case, capital murder case? I've seen other cases. I was retained in other capital cases, and I would have to look to see whether I testified or was deposed. Well, either way, you were under oath to tell the truth in either occasion, deposition or court?
Yes, sir.
Okay. So when did you become involved in this case?
That would have been, let me just check my records. That would have been back in, I believe it's March of 2024.
I have a deposition for 2023.
Oh, it might have been 2023. Let me look. Oh, I'm sorry. Yes, it was 2023.
And did you have occasions to, well, before I go on, are you licensed in psychology in any other states?
I have been licensed, most of my I've been licensed in New York and Georgia, but both of those licenses are currently inactive.
Have you published articles in your work as a psychologist or neuropsychologist?
Yes, sir. Published in peer-reviewed journals, authored poster presentations, oral presentations at national and international conferences.
And were those on the subjects of either psychology or neuropsychology?
Most of them were on traumatic brain injury with neuroimaging and or neuropsychology.
And I apologize to interrupt, Mr. Wood, but I have 3 people trying to watch the next of kin. They were given a Zoom link.
Oh.
So I'm just not sure that we're on the correct Zoom link, or we didn't give out the correct Zoom link.
I can give it to you. All right, I'll give it to you, and we can do it then.
Please. Thank you, Sue. Go ahead, Mr. Wood.
Thank you, Your Honor. So the next question I would have for you, Dr. Decerni, is for the purpose of review in this case and to assist you in your evaluation of Mr. Hunter and various matters in your field in this case, did you receive any materials to review in this case, and have you reviewed?
Yes, I've reviewed, let me just go back. So I've reviewed prior depositions from the initial trial by the experts, as well as other discovery provided by defense, as well as the recent deposition of Dr. Herzog.
Okay. Did you also receive a copy of your deposition?
Oh, yes, sir.
Okay. Did you also receive the Department of Corrections records?
Yes, sir.
Any other records that you recall that you received?
I'm just going to take a quick look here. Well, they're mostly reports and depositions, and I did receive some raw data from Dr. Herzog.
That was actually my next question.
Oh.
And we'll get into that in just a moment, but when you, for the benefit of the court, what are you talking about when you said you received raw data from Dr. Herzog?
He sent the handwritten protocol for the California verbal learning test that he administered, and he also sent the computerized scoring printout.
Okay. And did those materials that you outlined assist you in your formulating an expert opinion in this case and your testimony here today?
Not particularly. There was nothing that was all that strikingly different.
You talking about? Are you referring to Dr. Herzog's testimony or the other?
No, in the raw data.
The raw data. Okay.
Yeah, the Dr. Herzog's testimony has influenced what was used in the preparation for the opinions I'm offering today.
During the course of your involvement in this case, did you have the opportunity to meet personally with Mr. Hunter?
Yes, I have.
And when was that?
Let me just go back to my records for a minute here. That would have been looks like that would have been on the 9th.
What month and year?
I'm sorry?
What month and what year?
Oh, sorry. I'm sorry. The 9th of, it looks like that was the 9th of March, 2023.
All right.
Actually, it was I'm sorry, it was the 8th.
And what other occasions?
And then I met with him, looks like it would have been on the 6th of April, 2023.
All right. Now, and this was this at Union Correctional that you met with Mr. Hunter?
The first date was at Union Correctional, and I believe the second date was at the Volusia County Jail.
Okay. So, and what was the purpose for meeting with Mr. Hunter as far as what your intentions and what your plans were with regard to him?
I was asked to evaluate his cognitive abilities and to evaluate any impact of those on his actions and behavior.
Okay. And on the occasions that you mentioned, was there testing done on Mr. Hunter on both occasions?
I believe so, yes.
And did you conduct more than one test on Mr. Hunter?
Oh, yes, we conducted a full battery of neuropsychological tests.
I won't ask you to name each one, but can you give an idea, approximate, or an exact number of over the 2 times that you met with Mr. Hunter, how many tests were performed or evaluations were done? Less than 10, more than 10?
Oh, more than 10. So, 1, 2, 5, 6, 7, 11. It's like 12 what we call psychometric tests, and then there were several other neurobehavioral, what we call sign tests, in terms of just having him do things that were more idiographic, where either he can do them or not do them, rather than being compared to a norm.
I'm going to focus on one particular test that was performed. According to my notes, you did conducted the California Verbal Learning Test, second edition.
That is correct.
Okay. And what's the purpose of that particular test? What is it a test?
It's a list learning task and assesses basically memory acquisition, retention, recognition for verbal memory.
Okay. Is it a test where you orally ask questions of Mr. Hunter, or does he have to write something out or fill something out?
No, it's completely orally administered. He's read a list of words. At the end, he's asked to recall as many of the words as he can. And there are 5 trials like that. I'm sorry?
Within the 5 trials within the test?
Within the test, there's 5 trials, 5 learning trials. Then there's a distractor list, or a list of alternate words. And then there are recognition or recall trials that are for immediate and delayed recall, or a short-term and delayed recall. And then there are recognition trials. Can he recognize the words? And then there's also a forced choice section, which really is not memory. That's more of a validity indicator that's embedded in the test.
Okay. To see if the subject is giving best effort, feigning, or exaggerating?
Exactly.
Did you, before I go on, did you see any indication in that particular test, or your testing of Mr. Hunter overall, of any feigning or exaggeration or manipulation or malingering?
No, sir. We put forth full effort, and all of the embedded and standalone effort measures were consistent with full and adequate effort.
Okay. And is that a particularly long test? Does it take a lot of time to do?
Yes, it's the initial trial. There's the initial trials, and then there's a alternate list that's read, and then there's a recall trial. Then there's a 20-minute delay, and then there's a second recall trial. And these are there's free recall and queued recall.
Okay. And regarding the results of that particular test, can you tell the judge what your raw data, what your testing data disclosed with regard to that particular test?
Certainly. Let me just, if I can just refer to my notes for a minute. What we saw was that there was generally average to low average performance acquisition, and then there was average to low average recall, and queuing, or giving categories of words to help him recall the words didn't in this case did not aid the memory, which is I'll point out, is different than the results that Dr. Herkoff found.
We'll get into that in just a few minutes, but
okay.
So, and so what did you see on the test that you, in terms of the data, that was a low average score, resulted in a low average score?
It was mainly variations within learning trials. Sometimes they were all at the lower end of average. Sometimes they would go into the below average range, depending on the particular trial. So there was variability in his learning slope.
Was this test related to ascertaining what we would call executive function?
Not exactly. This is more of a memory test. There are executive aspects of memory, But this test is more of a memory. The cueing is a categorical aspect, which is an executive function in theory. But this does not have aside from the attention, does not have a particularly heavy executive function component to it.
Within that testing or other testing, did Mr. Hunter indicate below average for processing speed?
On the IQ test, his processing speed the processing speed index fell into the below average range.
Okay. You mentioned previously in your deposition about verbal abstract. What is that?
There's a measure on the IQ test on the WACE for verbal abstraction, the ability to see similarities among things that are not direct. So, for example, the symbolizing what are a horse and a cow alike, for example. And an abstract answer would be they're animals. But you could have a concrete answer such as they have 4 legs, they have hair, things like that.
All right. So as far as the testing, and by the way, were there any other tests that you saw in the raw data that Mr. Hunter was below average?
There was one, I believe there was one other processing measure that was below average. It was in the below average range. That was the trail making test part A.
I'm sorry, could you repeat that again?
Sorry, that was the trail making test part A was in the below average range.
For the benefit of the court reporter, is that trauma or spelled differently?
Trail making.
Trail making, okay.
Right. Tango, Romeo, Alpha.
Yeah, it just on mine just sound like, and I have that in my notes. So tell us about that. So what's that test for?
It's a very simple test of really psychomotor speed. There's a motor. There are a series of numbers, and the examinee has to draw a line connecting the numbers in order as quickly as possible, and they're distributed around the page and not in a direct sequence. So they need to follow the sequence around and search for the numbers.
Okay. And I think one of the tests that you did was labeled controlled oral word association.
Yes.
And how did Mr. Hunter do on that test?
Yeah, I believe there was some discrepancy. On phonemic fluency or production of words based on the sound, he was in the below average range. And when we looked at category fluency, it was mildly impaired. And those are associated with executive dysfunction.
Okay. And could you explain a little bit more in terms of Mr. Hunter's ability to take in information, understand and process information? What are we talking about here?
Well, that's more the ability to sort of categorize and determine differences between bits of information quickly, so that he's able to either develop categorical understandings or some other method of grouping things together and provide that information.
Okay. Did you, in the other testing, any other deficits that you noticed in the testing that you did?
The primary deficit, as we discussed, I discussed in my deposition, was the verbal abstraction. There's some indications of slower processing speed, and the controlled oral word association test that was impaired. There's also other indications of some slower processing. On the Stroop test, although the main purpose of the test, which is response inhibition, was average. So those are the primary findings from the examination.
That doesn't look like a mini doodle.
I'm sorry?
Yeah.
What? What just happened? Somebody was not muted. Looked like a mini doodle. What in the world?
I'm sorry?
Yeah.
The primary, those are the primary findings from the examination.
That doesn't look like a mini doodle.
I'm sorry?
Yeah.
Is my dog? Oh,
No, you're fine, doctor. It's all right.
okay.
Bless you.
Okay.
I apologize. Amber is a vet tech, so I suspect it was her.
Oh, there's a vet
Wait,
tech
proceed.
watching. That is so funny. I mean, here we go. Comedy to the chaos. So she's a vet tech and she was unmuted and she's talking about the dogs. Bless her heart. And so the deputy bailiff guy jumps over there and runs to try to mute her. Oh my goodness.
Thank you. Doctor, so in kind of breaking this, your data and interpretation of the data, evaluating the data, in terms of Mr. Hunter's, when you talk about processing speed, is that being able to consume or take in information and understand it or process it quickly or slowly, or is there kind of a layman's way you can explain that? Doctor, can you hear me? I don't see the mute thing. Doctor, can you hear me?
That we are.
Doctor, can you hear me?
Yes, sir.
Okay. I'll repeat it. Did you hear my question to you?
I do not believe so.
Okay. Let me repeat it. So in terms of a layman's interpretation of the verbal abstract and the processing speed, if you could explain to the court as it applies to Mr. Hunter, does he have Mr. Hunter have an impairment, in your opinion, about to take in verbal information and be able to process it, mentally and understand in real time, what's going on?
In terms of concrete information, and the things that would be at issue, in terms of understanding language, responding, being able to manage concrete information, there's really no impairment there. It really is in a more abstract ability to understand abstract concepts and to see sort of the larger picture, and be able to understand how the individual actions may influence other occurrences down the road.
So you're talking about being able to process and understand the repercussions or the net effect of his actions. Is that what you're talking about?
Yes, basically yes.
Okay. And in your opinion, does that interpretation apply to his actions in this case, his impairment to understand or process the long-term consequences of his actions?
Yes, and not just the long-term consequences of the action, the magnitude of it, but also to be able to understand how things might transpire. For example, during my deposition, I use the example of frying a turkey. You go out and fry a turkey, great, but you don't, if you don't have an abstract understanding of everything that's involved in that, you don't realize the inherent danger and how it could go wrong. So there's a difference between using a chain to lower the turkey versus using a rope or a nylon cord. Concretely, you're doing something to lower the turkey.
Hello. All right, I think that we're going to have to.
I understand.
Thank you.
Oops.
I'm gonna ask that she just be removed, and if you can let her know why. Thank you.
Judge. Apologize.
No apologies necessary. Thank you.
Thank you, Judge. And I certainly don't want to miss anything. Is that your, so the example of frying a turkey and the consequences of not doing it properly and the dangerousness of doing that, is that kind of where you were going with regard to Mr. Hunter's abstract thinking or verbal abstract thinking in this case?
Yes, it's not just a matter of doing it properly, it's being able to anticipate the things that could go wrong. And that's what gets us into the abstract understanding the activity. People when they're not able to abstract, don't really. It's harder for them to anticipate the consequences of what they're doing, and I don't mean concrete consequences, but the downstream implications, or what could go wrong, and that's the same people like, what could possibly go wrong. That's what requires abstract thinking, is the ability to see the greater picture of that particular activity. And his ability is, compared to his other functions, that's a significant weakness in terms of his cognitive functioning.
So, kind of moving on, you talked about, you received from Dr. Herkov his separate testing on the CVLT test?
Yes.
And which version was that?
He used the most recent version, the CVLT-3.
Is there any, let me ask you this one, what's the difference between the second version and the third version?
Primarily the normative sample, and the main reason that at that time we used the CVLT-2 was, although the CVLT-3 had been out for several years, I think it came out around 2017 or 2018 perhaps, the platform on which the CVLT-3 was stored was remote. So you had to go into a website which was actually housed in Canada to score the test. And they did have a paper version, but you put it into the scoring program, which was online. And since at that time I was doing a lot of federal work, we were prohibited from having data stored outside the United States. So my practice did not use any of those instruments that had the data stored outside the United States, which was why we use the CVLT. Because the status is primarily the same. And there's I think there's a difference in the force choice, but the word lists are the same. And it's just a more updated normative sample.
Okay. So having reviewed Dr. Herkov's raw data, does his data on the CVLT test change your opinion, alter your opinion with regard to the opinions you've been providing here today?
Well, his testing shows a much more impaired learning. So what he shows in terms of the updated sample, because the raw scores were not particularly different, but what they did show is that initially Mr. Hunter was able to recall an appropriate number of words and was average, but then didn't learn as quickly as he would have been expected to. So
I'm kind of bothered by this, listening to this, because as I listen, it's just trying to basically say that he's not smart enough, and that I feel like this is what they're trying to say, is that, let me dumb it down for you. It's like he's stupid and didn't know what he was doing, and he had some personal issues, maybe mental health problems, and oops. I don't, that's what I'm getting out of listening to this. I don't like it.
So his scores actually declined as he was presented with multiple trials.
Okay. And are there, with regard to testing on a particular individual, are there things? Let me ask it this way: can things like fatigue, lack of sleep, stress, noise, can any of those affect the data outcomes in any particular test?
Oh, definitely. I mean, one of the fatigue is a very significant problem. Noise, distractions are a problem. Other, interruptions or other people present during the examination. There's a large literature on what they call third-party observers, which impacts the data as well.
Okay. With regard to those examples I just gave you, did you see from your observations on the times that you spent with Mr. Hunter any signs of fatigue or stress or refusal to do the test or anything like that?
I mean, he put forth good effort. The issues that we tested him over an entire day. So we tested him for a couple hours in the morning. He took a lunch break, and we tested him for a couple of hours in the afternoon. So it's a long day. You know, he was in prison, which is a stressful environment. And for at least some of the tests, he was cuffed. So we're probably not. There are probably factors that come into play that cause variability in the testing. But all in all, I would consider this to be a valid assessment of his functioning, because there was no significant fatigue where he was unable to pay attention or things like that. He was very cooperative and exhibited good motivation throughout the testing. So I would consider this rather a valid assessment of his functioning.
Okay. And on the last subject, I'm going to ask you a few questions about, if past his prologue, what is your hourly rate in this case?
$300 an hour.
And do you have an estimate or an exact figure of how much you charged JAC so far for your involvement in this case?
Let's see. I guess are you talking about the initial trial or just the more current?
You're talking about the 2023 involvement?
Right.
Yeah, go ahead and it's up to you if you want to break it down or something like that.
Okay. Let's see. 2023. I'll put it here. I think it was a recent invoice. Okay. Let's see. So getting bogged down in JAC billing here.
We all do that.
Yes. I want to say it was around. I want to say it was around $8,000.
Okay. And then what are we looking at for this year's resentencing and involvement?
Okay. We billed them in April for $1,691.85, and the anticipated billing, including today's testimony, is going to be around $3,000.
Okay. Were you ever asked by myself, anybody on behalf of the defense, or anyone to alter or change or manipulate any of your testimony or opinions or any acts you performed in this case?
No.
Okay. And would you have done so simply because you're being paid?
Oh, I'm an advocate for the data, sir.
Okay. I don't have any other questions.
Thank you.
May I inquire, Judge?
You may.
Good morning, Dr. Discerni.
Good morning.
You did not testify before the jury in this case, right?
That is correct.
You've only testified in one other death penalty case, and that was for the defense, correct?
I believe that is correct.
In all of your work in the legal system in Florida, you've never been retained by the state attorney's office, is that correct?
That is incorrect. It's more recent, but I've been retained on, I think, 4 or 5 cases in the last month by the state attorney's office.
What state attorney's office?
The 6th District.
And for what purpose?
I believe they're all competency.
So in the realm of death penalty mitigation, at least, no state attorney's office has consulted with you, correct, or hired you? If that's correct?
Yes.
And then at the time of your deposition, no one from the state attorney's office in Florida had consulted you for any reason, but you're saying now in the last month, 6 have consulted with you. Is that right?
That's correct. There's a training in order to you have to go through in order to be retained by the state attorney's office, and I did that training last 6 months ago or so.
You have not reviewed Jerone Hunter's prior trial testimony from 2006, is that correct?
No, I do not believe so.
You have not reviewed the interview he gave to the police, correct?
No.
You have not reviewed witness depositions, is that correct?
I've reviewed professional or expert witness testimony.
Right. So the only depositions or prior trial testimony you reviewed has been related to the experts, correct?
Correct.
Did you review Dr. Reed's same depo?
believe so. Let me just check. Yes, I did.
How about Dr. Herkov?
Yes, I did.
Okay. Did you get a transcript of his trial testimony, or did you just rely on his deposition testimony?
To whom are you referring, ma'am?
Dr. Herkov.
I just have his deposition. I don't have his any trial testimony.
You met with Hunter 2 times, is that correct? Or over 2 days, but multiple times on one of the days?
One day we met with him twice, and on the third day we met with him 1 time.
Was that recorded?
No, ma'am.
You're saying a we. Who was present with you?
On at least one of the occasions, my technician was with me.
So no attorneys for Mr. Hunter, correct?
No.
Did Hunter admit to any of the murders to you?
No, ma'am.
Did you talk to him about what he was thinking that night?
I do not believe so.
Or the events leading up to that night?
No, I read Dr. Harper's deposition, who went into great detail about that.
So no, you didn't talk to him about the events leading up to the murder?
He mentioned that he was living with these people and were going to go back to get some of, I believe, Mr. Victorino's belongings, and that they had been, I believe, using drugs and perhaps alcohol. But that was vaguely all he said.
Is that what he said to you, or that's what you read in Dr. Harper's deposition?
I'm not sure which is which in recollection, what he actually said versus what was in the deposition.
Well, did you ask him what happened during the murders?
No.
Did you ask him what he did after the murders?
No, ma'am.
Did you ask him what he was thinking after the murders?
No, ma'am.
Or about what he thought of the consequences of bashing someone in the head with a bat, things of that nature? Did you go over any of that with him?
We discussed, ma'am.
When you were meeting with him, was he able to focus and participate in the testing with you?
Yes, ma'am.
Was he able to communicate effectively with you?
Generally, yes.
Did he appear to be talking to someone who wasn't there?
No, ma'am. There were times where he would become or lose his focus, but he didn't appear to be responding to internal stimuli.
Okay. Now, you did administer, would you agree, almost 60 different data points?
Well, I don't know offhand, but the tests generate multiple data points, so it may even be more than that.
Is it fair that out of those, over 50 fall in the average or low average range?
Yes, which is actually striking when we see something that is so far out of that range that becomes very important.
Would you agree with me that that's not indicative of a deficit?
No, ma'am, I would not agree with that.
I want to talk briefly about some of the testing you did. So the Wechsler-Adelt Intelligence Scale, that's the test of his general level of intelligence, right?
Well, it measures many things. One of them is a general IQ measure, yes.
And his result was an average result of 96. Is that correct?
Which score are you talking about?
Did he achieve a full-scale IQ of 96?
Yes, but that is not a unitary construct.
Okay. Well, the full-scale IQ of 96, does that place him in the average range of measured intelligence?
Again, yes, but that is not a unitary construct. So what's happening is it's not actually an overall accurate measure of his intellectual functioning.
You administered the brief visual memory test, correct?
Correct.
And on this test, his visual learning and recall was average and in some cases into above average, correct?
I believe so, yes.
The delayed recall was above average also, correct?
It was at least average. It wasn't, it might be above average. I'd have to look. If you'd like, I could do that.
Yeah. Take a pause for the cause. Child abduction, Amber Alert, local Amber Alert, missing child from Houston, Texas, suspect vehicle, black 2024 Kia Forte with South Carolina license plate 317 BIA. Missing child is Sky Mailer, 16-year-old white female, last seen wearing gray shirt, black shorts, white sneakers. Suspect is Nathaniel Young, 22-year-old white male. Call Harris County with information. If seen, call 911. No. Yeah, no. That was child abduction in Houston. Freaked me out.
Take a look. If you want reference, you can look at your deposition, page 19.
I've got the data right here. The delayed recall, yes, it was above average. Yeah.
You administered the complex ideational material from the Boston Diagnostic Aphasia Examination. Is that correct?
That's correct.
And that's like a verbal comprehension test. Is that correct?
Yes, it's a test of assessing comprehension of verbally presented sentences in short paragraphs of increasing and complexity.
And he did average on that test, correct?
That's correct.
You administered the Stroop test, right?
Yes.
And on the executive functioning aspect, the ability to inhibit behavior, he scored average there, correct?
As I stated earlier, there was an indication of slower processing, but the executive function measured by that test were intact.
Right, his ability to inhibit his behavior and control it was average, right?
That's not exactly correct. The score on that test was average. There are a variety of measures of one's ability to control and inhibit behavior. That's just one of them.
Right, and so on this one, he did average.
On that particular test, yes, he performed average.
You administered the wide range achievement test, right?
That is correct.
And everything was broadly average with the exception of math computation, which was below average, correct?
Correct.
You administered the complex motor tasks, correct?
Correct.
And that's executive functioning related, right?
That is correct.
And he had no error in reciprocal coordination, right?
And I believe the error was in response inhibition.
Right, so he had no error in reciprocal coordination, right?
The error was in response inhibition.
Right. So, and his performance on the graphomotor control was pretty good, right?
I believe so. As I stated, the problem with that, the finding on that exam was problems inhibiting motor behavior.
You administered I may not say it correctly, the Retan-Clove test?
Retan-Clove sensory perceptual examination, yes, ma'am.
Visually, he was fine, right? No indication of impairment?
Let me take a look. Are you talking about gross confrontation to visual fields?
I'm referring to your deposition, page 23, if that will assist you.
Okay. Well, let me take a look at the data.
Sure.
Yes, the visual fields were intact to gross confrontation. That's correct.
Okay, we're going to move on to the booklet category test.
Well, but ma'am, let me just say, I believe you're leaving out the positive finding that there were subsections.
Dr. Deserti, if defense counsel wants to get up and ask you any follow-up questions, he can, but please just answer my question. The booklet category test, that test measures problem solving and concept formation, correct?
Yes.
And that's an executive task, is that right?
Yes.
Hunter achieved an average score, correct?
Correct.
The grooved pegboard, which measures fine motor dexterity, was his score average there too?
I believe so, yes. Actually, let me just look really quickly. Since you'd like me to answer your questions, let me make sure I'm doing them accurately.
Thank you.
There were The T-scores were average, but there was one error in the dominant hand.
And you administered the speech sounds perception test, is that right?
Yes, and the seashore rhythm.
And the speech sounds perception test, that measures the persistence in terms of attention, is that correct?
Yes, that's correct.
And it also assesses sensory auditory processing deficits, right?
Only central auditory processing deficits.
And again, Hunter's performance was average, correct?
Correct.
And the seashore rhythm test, that's a faster version of the previous test we just discussed, right? But with reduced structure?
That's not exactly accurate.
Is that what you said in your deposition?
I'm sorry, ma'am?
Is that what you said in your deposition?
I can go back and look, but it does have reduced structure and it is faster, but it's not the same type of test. The stimuli are quite different.
Is it by comparison a faster test with relatively reduced structure, and that's a more pure attention test, and that actually was above average? Does that sound about right? I'm referring to your deposition, page 25, if that assists at all.
Speech sounds perception test was average. The seashore rhythm was above average.
Okay, so his performance was above average on the seashore rhythm test.
Correct. Yep.
You administered the paced auditory serial addition test, is that correct?
Yes.
And that measures attention and working memory, right?
Primarily working memory, but yes, there's an attentional component to it.
And Hunter was average?
Yes, he's not really demonstrating any attention problems.
The judgment of line orientation test was also given, correct?
Correct.
And he only made one error on that, is that correct?
That's correct. That was perfectly within the limits.
You determined that Hunter was ambidextrous, is that correct?
I believe it was mixed dominance, but let's look.
I'm referring to page 26 of your deposition, lines 10 through 11, if that assists.
Oh, yeah, let me go back and look. I just don't remember whether it was ambidextrous or mixed dominance. And I'm sorry, you said page 26?
Yes, sir. Your full answer starts on line 6, if you want to read through 11.
Oh, yeah, okay.
Did you determine that he was essentially being ambidextrous?
That's what it appeared to be. We did not do dominance testing, but it appeared that that it was incomplete dominance or incomplete lateralization. And it appeared to be ambidextrous.
Okay, thank you. You're not testifying that Hunter's capacity to appreciate the criminality of his conduct was substantially impaired, correct?
No.
You're not testifying that he was under the influence of extreme mental or emotional disturbance, right?
I haven't offered an opinion regarding that.
Okay. And would you agree with me that Hunter knew that if he bashed a person sculling with a bat, that they're likely going to die?
I didn't offer any opinion related to that.
So you can't offer an opinion about whether or not he would know bashing someone in the skull that they would likely die? Is that what you're saying?
I don't A, that that's true. B, I am not prepared to offer an opinion on that.
How about whether or not he would know if he killed someone, he may go to prison?
I'm sure he's aware of the penalties for crimes.
No further questions.
Ooh, she got a little snarky with mine.
Yes, sir.
Dr. Lynn, let me just follow up on some questions and then and we'll be done. So, Dr. Harper, the doctor you referred to, she's a psychologist?
Yes, she's a forensic psychologist, I believe.
All right. And your role in this case was strictly to do an evaluation on Mr. Hunter as a neuropsychologist and do neuropsychology testing?
That is correct.
Okay. Now, you did receive, Dr. Harper's deposition. You testified to that, correct?
That is correct.
And in that deposition, there's a narrative where Dr. Harper did, in fact, talk to Mr. Hunter about the events in question, correct?
That is correct.
And would the same be true with regard to Dr. Herkov's evaluation in time with Mr. Hunter, where Mr. Hunter talked about the events, the murders, the burglary, all that?
I do not believe that was part of Dr. Herkov's deposition.
In your role, your role in this case, were you ever tasked or asked by the defense to ask Mr. Hunter of the murders, the burglary, the events in question in this case?
No, sir.
When you do an evaluation on a client, other than, well, in general, do you record your evaluations with your patient?
No, sir.
And you do, in your practice, routinely meet with live patients, right? You do interviews, testing, all that?
Yes, sir.
Why do you not record your time with the client?
Well, there's a substantial literature on recording third-party observers having an impact on the validity of the testing.
In what way? That they might say something to please the third party, or am I getting it wrong?
Well, they may, depending on the nature of the situation, they may put forth, extreme effort, or they may act some way differently than they would in a normal, in a non-observed situation.
Okay.
I have a problem with that, because if they took him into an interview room and they sat down and they talked with him, the interview room more than likely would have cameras and a recording. And I think I'm confused. I think I'm confused at all this comment right here. I'm not sure. I think I'm confused.
It can also increase anxiety, which might impair their functioning to some extent.
Is it important for you? And
so they couldn't record him because they were afraid of making him anxious, so they didn't record the interview? Y'all, I think I'm confused.
Conducting testing and evaluation to have the client be, as much as you can control the situation, to be under less stress, to be able to have an environment where the patient can answer questions in a more relaxed setting?
Yes, there's an optimum level of anxiety that is required to keep people attentive to the task. And once we go beyond that, it's referred to as the Yerkes-Dodson curve. Once we go beyond that, it impairs their performance dramatically.
In this particular case, I'm writing a note down. I wrote down, were there times when Mr. Hunter, when you're spending the time with him, that I think you mentioned it appeared that he had lost focus, was losing focus? Have I got that correct?
Yes, there were a couple of occasions where he would, I don't want to say drift off, but would just sort of, it wasn't during task, it was during periods between tasks where he would just sort of drift off.
Okay.
Okay, so he got bored and started staring at the cobweb on the wall. Wow. Okay, Cindy, anytime, hon. We're here. Glad you came. Yeah, I mean, that was just kind of like...
Were those like long periods of time, short periods of time? How would you?
I mean, I drift off just listening to this sometimes. I mean, could you imagine if you're sitting in an all-day interview, and then you take a break from the discussion? Yeah, of course he's going to... Oh, God, this was stupid.
Less than a minute, usually.
Just my opinion.
Whether, when you make those observations, did you interpret it to be signs of fatigue, or was it for yawning or anything like that?
There was no yawning. The question of whether it was fatigue. He also did report, and I don't believe this occurred during the testing, but that he did hear his brother's voice on occasion.
I'm sorry, that he did hear his brother's voice on occasion?
Yes, sir.
And was that on the same day, different days? How did you?
I had asked him about that, and because I questioned about whether the voice was inside his head or outside his head, and he said it sounded like it was inside his head, and he recognized his brother's voice. And That did happen on occasion.
When you had those times, did Mr. Hunter, did his demeanor change at all? Did he seem to get angry, or any behavioral change you saw when you saw this or made this observation?
Okay, I need to pause there because I need to explain something for people that were not here for the trial. I mean, if you ever want to go back and watch it, is on my Rubber Ramada channel, my original channel. The complete trial is there. But let me explain for y'all in the background that are unaware. The brother situation is he had childhood trauma. Jerome Hunter, his defense gave evidence that he's had this traumatic childhood, and it was the death of his twin brother, and he witnessed a lot of domestic violence and all that. So they're trying to say that, good Lord, during all this time and his youth, he spoke to his deceased twin brother, and so they were saying that this was part of his mental issues. And then witnessing all the domestic violence throughout his life was part of that. So I think they're trying to bring this up again so the judge can weigh on the aggravating circumstances, that and the impact of his brother's death and traumatic childhood is supposed to be a crucial mitigating factor, for the judge to consider in making this a death penalty or switch it to a life sentence. So that's where that is. That's where they're talking about this brother. So I just want to let y'all know the background a little bit, because that's kind of confusing if you didn't understand.
Questions?
No, sir.
Okay. I don't know if were they on, you went out to see Mr. Hunter on 2 different occasions. Were they those times when you said he was talking to his brother, did they happen on both days, one day?
I believe it was both days, but I just asked him on one occasion, during one of the incidents, and he told me about his brother's voice. I didn't pursue that on the other incidences.
I want to go to what Mr. Dennis was asking about the general of the full scale IQ. You had mentioned that there's subsets of that Wechsler IQ testing that did you notice any deficits or below average subsets within that IQ testing?
Yes, and the IQ test is it's basically a four-factor subtest. You have the overall IQ, and then if there are discrepancies within or among the index factors, that would indicate that the full scale IQ is not an accurate measure, because it's hiding variability within that measure. So then, if there's no variability among the subtests, we then look to, or actually whether there is or is not, we then look to the individual factors: the verbal comprehension index, the perceptual reasoning index, the working memory index, and the processing speed index, to see if those are in fact unitary constructs. In other words, all of the subtests that make up those indices are roughly the same. And in the verbal comprehension index, which is comprised of the similarity subtest, the vocabulary, and information subtests, that index is not a unitary construct, because there is a significant weakness in one of those measures, that being the similarity subtest, which does, as we talked about, measures the verbal abstraction, and that test is markedly different than all of the other subtests. It's a significant weakness in that group of tests.
There's a significant weakness for Mr. Hunter in that verbal abstract subtest?
No, it's actually a significant weakness for the population. We look at whether something's a relative weakness, i.e. it's just a weakness, for Mr. Hunter, versus whether it's actually below average or impaired for the general population. And his just to give you a sense of this, the scaled scores, which is what we use for the subtest scores, the average is 10 and is a standard deviation of 3. Mr. Hunter's score on the similarities was a scale score of 6. So he's more than 1 standard deviation below the mean of the population, not for himself, but of the population used to standardize that test, and the ability to engage in verbal abstraction.
Okay. And I wrote this down too. There was in the response inhibitor testing, there was an error in that. Did I get that right?
Yes, that's yes. I wasn't able to continue on about that. There in the, I believe that was the Luria complex motor test. There's multiple things we look at to evaluate various aspects of executive functioning. Because executive functioning isn't one thing; it's a group of abilities that we sort of address as quote executive functions. One of them is to smoothly follow patterns and with reciprocal coordination. The other is your ability to inhibit your behavior, what we call a go/no-go task. And that's where the error occurred when he didn't inhibit his behavior in the go/no-go task.
And that's a motor skill function?
I'm sorry?
Was that a motor skill function? Is that what you're talking about?
It's an executive function.
Okay.
It's not motor. Yeah, it's not motor skill. It's actually an inhibitory function.
And in layman's term, what does that mean for Mr. Hunter?
Well, it means that he's going to have the potential for not being able to inhibit a previously learned behavior.
Just because y'all know me and know that I need to know some of this stuff. Okay. He kept saying go, no go task. I didn't know what this is. So, the luxury of AI mode sometimes. The go, no go task is a cognitive task used in psychology and neuropsychology to assess an individual's ability to inhibit or suppress an automatic or proponent response. It is a measure of response inhibition, a key aspect of cognitive control and self-regulation. Go trials. Participants are instructed to respond as quickly as possible to a designated go stimulus, for example, by pressing a button. No-go trials. On a similar percentage of trials, a no-go stimulus appears and participants are instructed to withhold the response. Okay, so it's just a testing. The main measures in the go, no-go task is the commission error rate, the percentage of times a participant fails to inhibit their response on no-go trials. According to Mind Hive Science, a lower commission error rate indicates better response applications. It's widely used to study executive functions and response inhibitions in both healthy individuals and those with neurological or psychiatric conditions such as ADHD or deficits in habit control. Okay. It's a valuable tool for the understanding the brain's ability to control impulses and override automatic responses, providing insight into mechanisms underlying cognitive control and self-regulation. Okay. Y'all, I needed to know. I didn't know what a no-go. This is how we learn. We learn together.
Or behavior that's ongoing. So he'll lose the set and respond when he shouldn't. Or to give an example of the test, it's really a matter of the standard response is somebody holds their hand in the air, you say go, and you have them hit the desk and come back up. In this case, the response set is the opposite. When you say go, you want them to leave their hand alone. And when you say stop, you want them to come down and hit the desk. And so he was unable to inhibit the go behavior, which is the learned technique. When I say go, he started to drop his hand.
Okay. Thanks, Ben. Does that tie into the
So maybe he was confused and couldn't follow the basic directions?
is diminished verbal abstract thinking in terms of processing information and responding to it?
They're connected because those are all executive functions in terms of response inhibition and verbal abstraction are all executive functions. So so when you put the whole picture together, you've got someone that's not able to fully understand consequences of, again, not concretely, but to understand the full picture in abstract sense, and then has problems inhibiting his responses, combined with a slightly slower processing speed.
Okay. That's all I have. Thank you, Doctor.
Certainly, sir.
May I release the doctor? No objection from the state.
No objection.
Sir, thank you very much for your time.
My pleasure, Your Honor. Thank you.
Any additional witnesses, Mr. Wood?
A live witness would be Mary Bunsen.
I'm sorry, I missed who they said this was. I was typing.
Yes, I do.
Good morning.
Good morning.
Thank you. Mr. Wood, you may proceed, sir.
Thank you, Your Honor. Ma'am, if you give us your full legal name for the court report, please.
Mary Teresa Bunsack,
Can you spell for the benefit of the court report your last name, please?
B as in boy, Oncek.
And thank you, ma'am. Are you related at all to Jerone Hunter?
I am.
And how so?
He's my nephew by my brother.
Okay. Where do you currently live?
I live in Valdosta, Georgia.
And ma'am, there's some bigger than topics I want to get to, but let me just ask you in terms of background. So obviously you're related to Jerone's mother, Annette Washington?
Yes.
Okay. And before Jerone, before brother Alicia and Jerone and Jeremy as well were born, were you aware of, or did you witness any physical abuse from Alicia Sr. on Annette Washington?
Yes.
And on more than one occasion?
Yes, sir.
In more than one city?
Yes.
So over just roughly, how long a period of time did you see the physical abuse between them?
It was years.
And so in terms of the locations, where was what city was the first time you saw them?
It was in Miami.
And where was Annette and Alicia Sr. living there at the time?
Yes, sir.
Okay. Were you living with him?
Yes, sir.
And was there anybody else living in the household with her?
Yes, I had other siblings as well, and my parents there as well.
So a lot of people in the house?
Yes.
All right, and then any other physical locations, cities where you saw physical abuse?
It was one home where we live in Miami where a lot of physical abuse happened there, and then we also moved in Carol City. It was also a part of Florida or whatever. And
let me ask you something that is going to be corporal. Was it Carol City that you?
Yes.
You know how to spell Carol?
Yes, sir.
All right. So, and you said this. You saw this over years. Was it like physical hitting?
Yes.
Were there times when the police were called?
Yes, it were.
Were there, when those times occurred, did Annette go forward with pressing charges against Alicia?
She never pressed charges. She always denied. Or when an officer would come, she wouldn't tell him that he was there, or she would not report to them and tell them what happened or anything.
Did you see physical injuries on Annette?
Yes.
And can you generally describe them?
He had black eyes, arms, legs. She even had a broken leg.
Over that period of time of the physical abuse, was there times when Miss Washington, John's mother, would separate from Alicia?
Yes.
Were those times very long?
No, not at all.
Did they, and that Alicia get back together?
Yes,
And did that happen more than once?
yes.
Did you try to keep them apart that period of time, or separate them? Have them move elsewhere?
No, I was young at the time, and she was not hearing what I had to say. I was only like a teenager at the time, so a grown adult don't want to hear from a child.
I will ask your age now. You might go to the. All right, so let's talk about now, when Alicia was born, Junior. After he was born, was there still occasions when Alicia Senior would physically abuse him?
Yes,
And did you see that after Alicia was born?
yes, I did.
And what city?
That was in Miami.
Miami, same residence, same location?
Yes,
Police involved in those things?
yes.
Same results, you know, charges? Is that what you're saying?
Never pressed on. No.
Can we get back together with?
Yes, she will.
Mark's bruises, same thing?
Yes,
After Alicia was born, but before Jeremy and Jerome were born, during that short period of time, did the abuse continue?
yes. Like I say, it continued for years.
All right. Were there occasions when the physical abuse occurred in the presence of Alicia Jr.?
Yes, it did.
Were there?
I want to take a moment to pause and say, I don't know if y'all can hear it, but there are people in the gallery back by where these cameras are in the back here, you know, behind all this going on, that are just steadily sitting there having a conversation. Just chat. I didn't call you Lola. Just having this big conversation, and I can hear them in the background while listening to this man, and I can actually make out what they're saying, and it's like, what are they even doing? Why they're talking about irrelevant things that just chit chat. I'm like, I can't, and with my ADHD and OCD, I'm trying to tune it out and just listen to him, but it's very, very hard.
Any times, just kind of going from now, Alicia Jr. is born, and we'll talk about when the other ones are born. Were there times when the Department of Children and Family Services got involved in the physical violence going on in the house at all?
I don't recall them ever getting involved in with anything that happened. Only thing I remember is the police coming out several times, and the mother they would ask, is that the person? And she would deny and say, no, that's not him.
Okay. So let's kind of take the next step. Jeremy and Jerome are born. Were you around in their lives after their born?
Yes.
Are we still in Miami at that point?
Yes, sir.
Okay. When the boys, Ron and Jeremy, are born, did you continue to witness physical abuse by Alicia Senior against Annette?
Yes, I did.
Was that in Miami or somewhere else?
It was still in Miami.
And did that physical abuse after the twins were born occur in your presence more than one time?
Yes, sir, I did.
Still physical injuries on her neck?
Yes.
No TCS involvement, taking the boys away, sheltering, anything like that?
No.
Police called still after they're born?
Yes.
Now, were there occasions after the twins were born where the physical abuse occurred in their presence?
It was always in their presence. Yes.
In the household or other places?
Inside the house.
And what kind of physical abuse? Was it punching, slapping, kicking, weapons, any description?
I never encountered it, seeing any weapons or anything. It was just like hands, where he would grab her sometimes by the hair or something. And
focusing on that time frame after the twins were born, when the physical abuse occurred in their presence, the twins' presence, was the abuse ever initiated by Annette? Or was it the other way around?
Only thing I would hear, like, it would go from an argument and then to a physical abuse. And that would be, I love my brother, but that would be him striking her, hitting her.
Did, after the twins were born, did Alicia Sr. ever get violent with anybody else in their presence?
Yes,
Who else?
he got violent with us, his sibling. Yes,
You as well?
yes.
Punching, kicking, what type of abuse are there?
One time, I recall him.
So she's talking about Jerone Hunter's father, her brother, and the abuse that happened growing up. And this, I don't understand how this is going to make any difference in what he's done.
Coming at me.
Okay. And he struck you?
Yes,
Were the boys at that time?
they was right there.
I mean, like,
and that's
they're
because
what are we trying to say here?
we would try to stop what was going on.
Okay. Was the boys trying to stop what was going on? It was probably fake.
Only the older one, Alicia, would try to.
He would fit Alicia Jr. would try to physically stop the fight.
Yes, he was a little boy. Yes.
Did you guys have any luck in that at all? Stopping the fight?
No, only after we were threatened to call the police or whatever, and then he will either flee the scene or he will, just sit there or whatever because he know that, and that would not tell on him or anything.
How did the twins, particularly Jerome, how did they react? Your observations of how they react when there were times when Alicia Sr. was abusing you, your sibling, and or the mother?
Well, after so much had went on, he was having dreams, bad dreams and nightmare.
Who was?
Jerome.
Okay. And tell us a little bit more about that. Was that, well, let me start here. Do you know roughly how old Jerome was at that time?
Yes, he was 2 or 3 years old at the time.
Okay. And we're still in Miami, right?
Yes, sir.
And then was he reporting to you about having the dreams of the nightmares, or did you hear him during the night?
We actually seen, hear him cry and scared.
Okay. When you saw that, was he drawing in the bedroom, or where was he at?
He was, I can't explain, because it was a big den that he used to be on, and he would be in there and he would be crying or whatever, and he used to always shake his head like no.
Jerome did that, shake his head no?
Yes, sir.
And is this when, like, is he, what was he like? Is he like waking up in the night, or when he's expressing this, or?
That would be time when he'd wake up and he would he would shake his head, I don't know, like he telling somebody or something no.
Okay. And was he having any other problems during that time, Jerome? Bedwetting, acting
Yes.
out in other ways, things like that?
Yes. Well, he was still, he was still pretty young, so at the time, I guess.
During that period of time, during the physical violence, everything, did anybody send him to a counselor, psychologist, get any kind of mental health treatment for Jerome?
Yes, sir. No.
Did anybody talk about getting treatment? I think anybody in the family talk about getting treatment?
No, sir, he did not.
Okay. All right. And then going forward from there, did eventually Annette move from Miami to some other location?
Yes, she did.
Where was that?
That was when they moved out of the home with us and they moved inside their own place.
They being Alicia Sr.
And the kids, yes.
And where was that?
That was in Kansas City at the time.
And did they stay there? Let me rephrase that. Did you go up there with them, or did you stay in Miami?
I was still in Miami at the time.
And did you have, when they moved to Carroll City, did you have much contact with them at that?
Yes, we did. It was like, it was over there like almost every day.
Okay. Now, had Jeremy passed away by the time they moved to Carroll City?
Yes.
Okay. Before I go on, let me pause for a minute to ask you about that. So, how was Jerone, how was Jerone's personality before Jeremy died? What was he like back then?
Council, can you approach for just a moment? I'm gonna have that super loud white noise. I apologize.
Oh, I tried to hit it before it came on. Okay, zoom. All right, she's still up there. They're doing okay. We got it. All right.
Very quickly, what was Jerone's personality? What was he like?
Are we back? I have no clue what just happened. It just dropped everything off the stage, and I have no clue what just happened. Oh, StreamYard's on the fritz again, damn it. Okay, back to this. Wow. Okay.
He, like I said, he always shake his head like telling something or someone no.
Were there occasions when, from your observation, it looked like Jerome was talking with somebody?
Yes,
Did you see that on more than one occasion?
yes,
And then going forward, Carroll City, do you continue to stay in contact with Jerome?
yes.
Did you like live up there or just come visit?
I live there.
And did you continue to see physical abuse during that period of time?
Yes.
On Annette, yourself?
No, it was Annette.
Same activities, getting back together after the abuse, all that?
Yes. My parents sent them away, her away several times, and Annette would come back, and it would be the same thing. Yes.
So going forward, roughly how long did you stay in Carroll City?
At that time, it was only probably 2 or 3 years.
Did you move from there?
I think at that time, years had went by. Like she finally realized that I guess had enough.
Okay. Did you move in with them in any other location after Carroll City?
No.
Okay. Now, when you continue to stay in contact with, did you continue to stay in contact with John after you moved away from Carroll City?
No.
Okay. And that would have been, how old would John have been at that point, just to get a reference?
Like I say, he was at that time 2 or 3 years old.
Okay. And for a claim of reference, did you continue to visit or have visitation with John after Annette married Dan Washington?
No, he had no contact.
All right. And did you continue to have contact with Alicia Sr. after you moved from Carroll City?
Oh, yes, yes.
Okay. Now, in that context, after Carroll City, from your observations, did Alicia Sr. having a relationship going forward with Jerome?
No.
All right. And do you know if that's still the case today, that they don't have a relationship?
No relationship, not at all.
Okay. And then, just 1 second, Judge. On an economic matter. So, the last time you lived together in Carroll City, was either Alicia Sr. or Annette working?
Yes, my brother, he was working, I believe at a tie shop or something.
At what shop? I'm sorry.
Tie.
Thank you.
Was she working at the time?
No, I don't think, no.
Was she having her own mental health problems?
I believe so, yes.
And what makes you say that?
Because of the action, after the physical abuse and everything that you need to stay in a relationship and do what you do. Yeah, you got a problem.
Okay.
And I'm not being funny or anything. I knew that as a child that was too much.
Last question. So going from, well, during the time in Miami, during the time in Carroll City, were there times when there were issues of coming, having food available or money in general between Annette and Alicia in the household?
Well, they stayed in our household with our parents, and my parents provide everything for everybody.
And were they providing financial support to them when you guys lived in Carroll City?
No, that's when my brother was working and financially paying whatever bills they had.
Okay. All right, that's all I have. Thank you.
Thank you. No cross judgment. All right, ma'am, thank you very much for your time.
Okay.
No cross on it.
Mr. Wood, any additional witnesses, sir?
So I have two things that I want you to see from the side. Okay, just so you know. This is clear as you. Because it's just no, choose. You have.
Yes. Just sign it.
Yeah, this is the east side. Judge, I have a couple of letters I'm going to put in evidence.
Okay, thank you.
The first one is the email letter from ESA Robinson. And Judge, just to tie it in, this is Miss Laydu's son that testified previously during the penalty phase. He lives in the station South.
Okay, thank you. I do recall.
I have reviewed that email. I have no objection to that coming in.
Thank you, Mr. Donis.
And then I have a 3-page letter, Thomas Tyler, understanding letter. We did business contacting Priscilla. Priscilla decided on this label, family. The state has a copy of this as well.
Mr. Donis, would you like to say anything regarding the letter?
I would. I have no objection to Your Honor considering it. I just want to make sure that it was just signed the Hunter family, the copy that I received. I don't know who authored it, but I understand it's the sentiments of the entire Hunter family. I received it with a copy of an envelope from Dallin Anderson from Atlanta, Georgia. But I understand now the copy is provided to the court. Somebody signed today, Fonseca, who is here in court. Did I give you say that Priscilla also signed it?
Yes.
If you don't, I don't. Thank you.
And Judge, the next document I'll put into evidence, and this is, now I'll show this as well.
Can I see the?
Sure.
That's all.
See, it should be like 9 through 25. And then I'll.
Oh, you have to make that in, so you're saying?
No, I haven't made minutes, but I have to take the discussions, they have legal discussions and all that, but I do think I mark and make that.
Okay.
If you can do some things, just let me know the page.
Yeah, sure.
Curious as to why Troy is on Zoom and not at the actual hearing.
13 lines 5 through 7. So I know there's, that's okay. I don't think it's 21.
Lindsay asked our clerk, do you want these just marked or do you want them admitted into evidence as an exhibit? How would you like that done? Okay, so
thank you, Lois.
We'll have them listed as exhibits and admitted. Thank you.
Judge, the next proposed exhibit, I provided a copy to the state. First, let me say these are transcripts from the original from the original sentencing hearing before Judge Parsons,
Yes, sir.
August 28, 2006. Before any redactions, I took out some pages that was legal argument before the witnesses.
I understand.
And for the record, the testimony, and then also some language afterwards. Morris Hunter, Teresa Horn, Janie Brown, Annette Washington are all contained in these transcripts. Now, there were 2 redactions that I agreed to make that the state was going to object to. You'll see them marking on here. And simply put, if there are 2 witnesses that asked the court to sentence Jerone to life, which there's a case, particularly the Burns case.
I was going to say, if Mr. Donis isn't objecting then to the form. No, I objected to that portion, but he just crossed it out, and I'm perfectly okay. I understand you can set it aside, so that's why we didn't formally redact it other than just crossing it out. Okay, gotcha.
And I guess I'll put on the record too, so what we're talking about as far as reductions is page 13, lines 5 through 7, and the other page on page 17, lines 21 and 22. So can I put redacted on top, Justin?
Thank you very much. And that would be, thank you.
We have a couple of demonstrative exhibits in just a moment, but I think the next step would be an allocution from my client, Mr. Hunter.
Yes, sir.
Where would you like Mr. Hunter to?
Thank you very much.
Just going to like a 5-minute break before we do the allocution.
Well, this might probably be a good time for lunch. It's almost noon.
Okay.
So I wasn't sure how much longer you were looking to go. If you're not going to go down.
Okay, and they do go to lunch. So we are going to take that luxury of Zoom that we are so blessed with on these little speed things. And this is why, even with trialing, with speed trials, I love doing speed trials because we just delete the fluff. So, all right, let's get back to this. Let's see. Bring the judge in. Judge is still not in. Oh, here she comes. Oh, back it up. Hold up. Here we go. Okay. Chew that gum, sir. Chew that. Boy, he's chomping away on that bubble gum.
What are you doing this weekend?
All right. So go back to work.
All right, everyone, please be seated. Ms. Wood? Oh, there's mine. He's fine sitting there if he's comfortable sitting there.
Okay.
You okay with that? Okay. We'll make sure we'll have the mic for him.
Just keep it. May I proceed, John?
Absolutely.
Okay. Let me put on the record, you are Jerone Hunter. Yes. Yes. Okay. Mr. Hunter, you have a statement before you that would you like to read that statement to the court, to the judge?
Yes.
Okay. You'll go ahead, please.
Back in August of 2004, I was part of something that destroyed a lot of lives.
Okay, wait, let me back it up because I was looking at something else. Okay, this is Jerone Hunter. He's making his statement.
Would you like to read that statement to the court, to the judge?
Yes.
Okay. You'll go ahead, please.
Back in August of 2004, I was part of something that destroyed a lot of lives. And for that, I'm truly sorry for all the pain, heartache, and trauma. The families I know, the hurt of tragic loss, and I regret every moment of my actions that took their loved ones from me. I'm truly sorry for the pain my actions has caused. I know my words of remorse and apologies can't change anything, but I want you to know that I understand the impact of those events that has been a dark cloud over the community for the last 2 decades. These words can't really give meaning to how sorry I am for my role in those unnecessary killings. That wasn't my intentions that night, and I don't know how I got to that point. Through the years, I've worked on my mental and emotional issues, meditation, which allows spiritual growth and self-awareness. I really want to be able to have a positive impact in this world, to help someone become a better person, to pass on positivity to the next person that may be struggling in life without direction. I understand the significant impact and devastation those murders has caused family, friends, and the entire community, including my own family and friends, because of my actions that night. No matter the reason, there's no excuse for what happened. I'm extremely sorry to families, friends, and community as a whole. Words truly can't express. During that time, I was a young, weak-minded idiot that made the most horrible choices. Not everything that was presented was true, but no matter the details, 6 people lost their lives and other lives were destroyed. There's no going back from that. Beyond whatever happens with sentencing, I want to be a positive influence in someone's life, making a positive impact in some way. To my family and friends, I'm sorry for all the negative things that you've had to endure because of my actions. I wish I could have been a better person in your lives. Thank you.
Thank you.
Thank you, Judge. Thank you, Judge. Judge, I think it might be, you should probably put a copy of the original and take a copy. If I may ask the clerk that as an exhibit,
Yes.
file the original, and we'd ask for a copy of that for all records.
We can do that. Thank you.
Then, follow up with some additional last documents to put before the court.
Yes, sir.
The first one, though, it's a 2-page document. I just didn't follow it. It's a demonstrative exhibit, instances of the state using the N word, and it's a page and a half, actually. And I would like, and I know we're going to be incorporating this into the our sentencing memo, our arguments, but because it's, I think, also appropriate to put this in to relay instances of in the transcripts of the proceedings, put this in as a next exhibit. I wouldn't say it on the
So we did.
Judge, the next exhibit I would put in would be there is a single page graph. It's titled Florida Execution by Agent Type of Offense. Cites some information, some graphs, and for the court for sentencing, but again, because it refers to data, we wanted to put this in a Spencer hearing, and I do believe the state has an objection on the glad to respond to the objection.
State's objection.
And then I understand you may need to review it to make a decision, but it's the state's position that this is irrelevant to your determination as to what is an appropriate sentence in this case. It's a chart talking about the number of people executed in Florida by age at time of the offense, and then at the bottom it mentions 2 gentlemen, and they happen to be black. So it's the state's position this is irrelevant for the court's consideration, and it should not be admitted.
Good snark, state. Good snark. They were, yep, I like that. Irrelevant.
All right. It's admitted over the state's objection.
Thank you.
It's admitted. Oh, okay.
And lastly, let me get Judge, as a composite, the next and last proposed exhibit for Mr. Hunter, there was mention of this. This has come up in previous cases. So Mr. Victorino, in case 2004-13-16, was charged with felony battery for an incident that occurred July 28th of 2004. I have the information, I have the docket that shows it was multiple, but the reason we're asking that it be an exhibit for the court's consideration and sentencing, not that it's an aggravator, in fact, it'd be a mitigator to support Mr. Hunter's argument about being under the influence and dominion of Mr. Victorino, being a fear of Mr. Victorino at the time of the murder. So we would like to put this as an exhibit for the court's consideration. And again, we'll be filing a sentencing memorandum that will include this information.
I have no objection.
So admitted.
Judge, I don't have anything else.
All right. Thank you.
And I know that the sentencing memoranda will be coming, and I'll be on the lookout for them.
Yes, ma'am.
Any argument, or do you want to wait until the end and I have everybody present their arguments?
I can do the argument after Mr. Victorino is
Okay,
concluded.
all right, thank you. Ms. Simmons.
Thank you, Your Honor. I am attempting to I'm just going to be putting in some exhibits, Your Honor, and then I'm going to ask for Mr. Victorino's video to be turned on at this point.
Yes, please. Oh, is he not? It's on?
The president needs to turn it on.
Yeah.
Because I need to make sure that he can hear and see me because I have to ask him
Absolutely.
questions.
Certainly.
And they need to unmute him as well.
All right, thank you.
So I think we have to wait until.
Oh, absolutely, that's fine. So I'm gonna step off the bench and go down the hall, and by the time.
Thank you.
Okay, all right.
Mr. Victorino, can you see me?
Yeah.
I'm waving. And you can hear me, obviously, because you just responded to that. Thank you.
Yes, ma'am.
Okay. So, Your Honor, the additional exhibits that I want to enter, the first is a letter. The year is very difficult to read, but it was associated with one of Mr. Victorino's juvenile cases in which he was sentenced as an adult. It's dated September 21st, 1990. I'm going to guess 7 or 8. But this is authored by Erin Victorino to the court, and it is part of the court file. So the state does not have any objection to it being entered. It is basically the most important part, Your Honor, would be what I think for the court is the fact that Ms. Victorino on pages, really it looks like the third and fourth page, described his prior abuse. So this was basically to indicate that there was Ms. Victorino had indicated that there was abuse and neglect and issues like that way prior to the homicides occurring in this case. So if I may approach the clerk and.
You may. No objection? No objection, Your Honor. I would ask you to disregard the stuff. You'll see when you read it, she talks about a study, juvenile criminals treated differently by race. But obviously all this stuff about the history of the abuse and her opinions on that, I have no objections.
Thank you. And that is why I wanted to preface the reason why I wanted to, because obviously a lot of that data is stale now. This is from the 90s. So it's not necessarily relevant for our purposes at this point.
Thank you. Straight in is fine. Thank you. And then, yes, thank you.
All right. The next document that I wanted to enter into evidence is Mr. Victorino's DC-14. It is dated as of August 14th, 2024. I did request an updated one, however, did not receive it in time for the hearing today. However, I may supplement the record with the additional one prior to the actual sentencing hearing, because I know that it will reflect the same exact data, which is that he has not had any disciplinary reports, especially since 2024, but basically since he's been incarcerated on this case. But he has some priors from when he was incarcerated before, which were testified to and explained by Mr. Bonosco, the expert that we presented at the trial. And I know the state doesn't have any objection. It is a public record.
Okay, so admitted. Straight in.
And the last I have, Your Honor, the state does have some objection to is a letter dated July 11th, 2025 from Antonio Victorino, who is Mr. Victorino's brother. The only portions that they are objecting to are, I believe, where he indicates in paragraph 1, 2, 3, 4, 5. Let's see, that they wanted to. Actually, no, it's
I can
6.
just read it if you
Yes.
want, like the specific lines.
Mhm.
There are 2 areas, Judge. Please allow me and my family to have just a little more time with this new version of Troy. And then lastly, I know that I have no right to ask, but I do implore you to please be lenient with him. Allow us and others to more fully get to know this version of him. Please extend your mercy towards Troy. And the state's objection, did you want to speak first?
No.
Just my objection is, it's not relevant to your determination of sentencing what family members on both sides want to have happen. That's not an aggravator or mitigator. I understand her positions too.
Our position is just that it's a request for mercy, which is going to be echoing what I'm going to be arguing anyway in the sentencing. I know that Your Honor can discern what he means by this. It would be strange for him to be asking for a different penalty other than a life sentence. So I think that it kind of, and in front of a jury, I understand that would be an appropriate hour in front of the court. I don't necessarily think that you can't discern the difference between those two things.
It's admitted over the state's objection.
Thank you.
Yeah, straight in.
And I know that I wanted to read it mainly because my client is not here, and I wanted him to hear it. And
Okay.
so if I may, unlike the others, it's only one letter, Your Honor, and it's one page, so it will not take up too much time, but I wanted Troy to hear this from his brother. To whom it may concern, I would like to thank you for the chance I have to express my feelings in regard to my brother, Troy Victorino. As the third child in my family, I was able to spend some time with my brother as children and in between incarceration periods. Looking back, I can honestly say it was nowhere near enough time. Growing up, as I am sure you have heard, Troy was the protector. So much so that it wasn't until after he was gone and the negative attention started being focused on the rest of us that I began to realize how dysfunctional our family dynamic was. And so as a child, I wanted to escape not just my house, but my family as well. I say this because it's only now that I'm in my 40s that I realize just what our trauma did to us and how hard we had to fight to survive and appear normal. This was especially true for Troy. I have personally seen the shell that he wore to protect himself fall away, so to speak, as if he literally shed his skin or changed his clothes. I listen in on the weekly conversations he has with my mother and younger brother, and am amazed by the genuine concern and comfort he shows to them. My own interactions with him, though limited, are now refreshing and something to look forward to, as opposed to the draining effect they once had. I share this with you because the Troy that stands in front of you today, I know, is different. I no longer want to hide the fact that we are related. Instead, I speak often of it and how he has changed so much. I know that the things that have been done cannot be undone. There has been such a loss of life, and that gift is ever so precious. I am not asking for forgiveness, but for mercy, please. Please allow me and my family to have just a little more time with this new version of Troy. As we draw closer, we continue to heal from old wounds cast upon us, and I continue to see these wonderful layers of my brother that I never knew existed. I get to hear expressions of how instead of fear of him, people are touched by the joy he can share with them. I know that I have no right to ask, but I do implore you, please be lenient with him. Allow us and others to more fully get to know this version of him. Please extend your mercy towards Troy. Regards, Antonio Victorino.
Thank you. Thank you.
And then, Your Honor, and if I may get up my water, please. Just briefly.
Certainly.
I'm sure Your Honor noticed I was going in and out a lot. I was attempting because Mr. Victorino had provided me with his copy of his allocution. I wanted to review it to make sure it was appropriate, make any edits that I wanted to make or suggestions, which I discussed with him over the break. The problem is that was his only copy, and I've been attempting to get the Department of Corrections during these past couple hours to print something out for him so he could read it himself. They had indicated to me that security will not allow it.
Okay.
So I am asking to read it for him.
Hearing no objections in the state, you may read it.
I am going to, of course, show it to him so he can authenticate it as his handwriting.
Certainly.
Except for the blue, which is mine.
Okay.
Troy, I know that it's going to be hard to see this. I don't even think that I can actually get it, but did you provide me with a one-page letter that is handwritten? Did you?
Yeah.
Yes. Can you hear me?
Yes.
Okay. You see that I'm holding it up? I know that you can't see this, but it's a one-page letter that starts "To whom it may concern" and signed humbly Troy Victorino.
Yes.
Okay. And then we discussed when we were talking earlier some of the edits that I had, and I had there was a blue ink of things you wanted me to add or change.
Right.
Yes, sir.
Yes, ma'am.
Do you have any objection? I know that you can't, but is it okay if I read this for you?
Please.
It sounds like it might be better anyway, because it seems like the volume over there is a little bit hard to hear. Okay. So, for Your Honor, these are Mr. Victorino's words. To whom it may concern, thank you for your time. I have spent the last 32 to 33 years of my life never accepting responsibility for my actions and behavior. I lied because I was scared to lose my family. Finding my faith fundamentally has changed who I am as a man and human being.
Wait, is she reading a letter from him? This is Mr. Victorino's words. Okay. Let's hear those words, because I'm not sure I was liking what I was hearing.
It may concern, thank you for your time. I've spent the last 32 to 33 years of my life never accepting responsibility for my actions and behavior. I lied because I was scared to lose my family. Finding my faith fundamentally has changed who I am as a man and human being. Because of this, I am deeply saddened and sorry for the tragic, unnecessary loss of human lives. This crime was horrible and could not ever be justified. Nothing I say will ever make things better or fix the emptiness of the loss of Erin Belanger, Francisco Ayo-Roman, Anthony Vega, Michelle Nathan, Jonathan Gleason, and Roberto Gonzalez. Their absence in the world is so noticed and cannot ever be replaced. Any good that I have done since giving my faith is a credit to them. My search is not for freedom, but for forgiveness. Spending my life showing others that they can change for the better, that they can be positive, productive, caring, and compassionate is on behalf of the victims and myself. This tragic loss gains nothing by adding more families to the list of victims. It gains everything by any positive, hopeful act that can be done on my behalf for Erin Belanger, Francisco Ayo-Roman, Anthony Vega, Michelle Nathan, Jonathan Gleason, and Roberto Gonzalez. I ask and hope this court will allow me to continue to do everything and anything I can on behalf of the victims. Thank you for your time and consideration. Humbly, Troy Victorino.
Thank you.
And Your Honor, that's the end of the presentation that I have.
Thank you.
So the only thing I have left is a very brief argument. I am reserving the vast majority of my argument for the sentencing memo, which I've already started to work on, where a lot of this is coming from. Do not worry, I'm not going to read everything I have here. I just wanted to basically highlight, I think that it was clear that this presentation of evidence was a little bit different than in the first case.
Yes.
The reason why is because, frankly, so much time has gone by. Troy Victorino is 48 years old today. He was 27 years old on the day of the Telford murders. Time does not heal wounds. It does not change those things. But what it does is reveal who you can be and who you are. The Troy Victorino of 27 years old was immature and childish and refusing to accept any responsibility for what he did. He was someone who scared people, as was made very clear in the motion to sever. There was fear surrounding him. I think that what we were able to present over the course in front of the jury was that, and I hope that many of them saw that, was that he fundamentally was a very flawed and broken person who used what he looked like and his strength in order to put on a very different front than what was inside, which was a child who had been abused, neglected, and quite frankly, even though loved by his mother, he had a very dysfunctional home life. It's not often, and once again, we have records that were put into evidence, and I will refer those in my sentencing memo, but it's not often that we see children who are hospitalized at a young age. His trajectory was damaged from the beginning, and once again, we're not providing any sort of excuses for why we're here. It is an explanation for how someone like Troy could get to this point. But one of the biggest differences between the prior sentencing presentation and this one is that Mr. Victorino has accepted responsibility. He continues to strive to continue to do that every day. He is a very good inmate. He has made differences in people's lives there. You've heard from those inmates. So the highlighting of what we're talking about here is who is he now versus who was he then, and is this somebody who should be subjected to the death penalty, or is it something that you should consider for a life sentence, despite, of course, the jury's recommendation, which I would remind the court is not unanimous. I've already filed motions to stay because of kind of pending litigation in Florida Supreme Court, where we have not heard yet on the Michael Jackson case, which I believe would have a direct impact on not only Mr. Victorino's case, but Mr. Hunter's. So, and those are things that I will argue in my sentencing memo as well. But I think that because these are not unanimous, because of how long this has been going on for, and the changes that you have seen and that we have proven have happened with Mr. Victorino that make him so different from that person when he was 27 years old, that is the basis for what we're going to be asking for you to consider a life sentence for him. And of course, I will be very detailed in our mitigating factors and describe which experts presented which facts. But it's clear that he has family support and love. There are people who care for him and continue to care for him. And while there's no way that we could ever speak for the victims in any way, the finality of a life sentence, I think, would be, or I would propose, would be very healing. Mr. Victorino would die in prison, and despite any litigation, any future litigation or any future jurisprudence from the United States Supreme Court or from the Florida Supreme Court, it will not affect him if he was sentenced to life. It would be over. And I think that at this point, who he is now, while he never earned it before, I believe that that should be considered now for a life sentence, Your Honor. And of course, I will reserve the remainder of my argument.
Thank you very much.
Thank you.
Mr. Wood.
Thank you. I do have some summation in writing I want to go over, but again, also we will have a more, do we have tissue?
Sure.
Tissue? Is the man fixing to blow his nose?
We'll have a great deal more in our sentencing.
Oh no, he's wiping his glasses. Okay, I thought he was fixing to just blow his snout.
I appreciate the opportunity to do some summation here. Court has an awesome responsibility, certainly at this phase in the proceedings, in consideration of, as we asked for the court to override the jury's 4 verdicts on the 4 separate verdicts of death the jury has filed in this case. The 2 main things that we will be dealing with both today and in the sentencing memorandum in terms of mitigation, although there's numerous other points we'll bring out in the memo, is that if Mr. Hunter had been if the crimes had been committed 66 days earlier than they were, Mr. Hunter would be constitutionally unable to be sentenced to death for these crimes. He was 18 years old and 66 days at the time of the offense. He was the youngest of the 4 defendants in this case, 2 of which have already received life sentences, Mr. Salas and Mr. Cannon. But as I pointed out in my summation and at sentencing, the number one, I moved it up, the number one mitigating factor in Mr. Hunter's favor is his age. And the second, in terms of order, as again I argued in resentencing, was that he was under the domination of Mr. Victorino, who's an older, 10 years older, significantly larger gentleman. I believe was around 300 pounds. Mr. Hunter was around 130, according to his coach. Research shows that Jerone possessed the same psychological attributes that the Supreme Court has categorically barred in death penalty cases and for mandatory life without the possibility of parole for juveniles.
But he wasn't a juvenile.
Youth that would be too much younger than him at the time.
No, he was 18 and what did he say? However many days? No, wasn't a juvenile. Stop it.
With a crime, and I refer to Roper v. Simmons and Miller v. Alabama. Again, these will be in the sentencing memorandum. I should also point out the state of Florida has never executed somebody that was as young as Jerone at the time he committed his crimes, and you do see that in the Exhibit A that has been filed here today. Previously, when the Supreme Court did push proportionality review, youth was repeatedly cited by the Florida Supreme Court in granting proportionality relief. Research shows that juveniles are constitutionally different than adults in three ways, and thus ineligible for the death penalty and even mandatory life without the possibility of parole. Juveniles have an undeveloped sense of responsibility, which leads to recklessness, impulsivity, and heedless risk-taking. Juveniles are more easily rehabilitated as their character hasn't fully formed yet. And most important here, juveniles are more vulnerable to external influence and peer pressure than adults. Teens are more likely than adults to be dominated, manipulated, or encouraged, especially by peers of older adults. Research indisputably shows that these three characteristics apply to 18-year-olds. I refer to the American Psychological Association, which passed in 2022. Again, this will be in our memo, a resolution supporting the view that 18 to 20-year-olds should not be subject to the death penalty for the same reasons as juveniles. And we previously it's in the docket, filed a Roper extension asking the court to consider the death penalty unconstitutional for persons under the age of 21. The court had entered a denial on that motion, but we preserved their argument. In the AMA, or the APA rather, has recognized the binary between juveniles under the age of 18 and adults over 18 as a legal fiction that does not reflect adolescent development. One of the powerful parts of Jerone's case for life is the intersection of his youth with Troy Victorino's domination and pattern of exerting violent pressure on everyone around him. And I do want to point out to the court that I personally have asserted the domination mitigator, statutory mitigation. Mr. Hunter has been concerned about this assertion and did not want it to be involved in the potential execution of another human being. But I believe that it is extremely important for my zealous representation of Mr. Hunter to make sure that this mitigator is front and center for the court to review and the evidence that's attributable to it. So I want the court to know that this is my strategy and my strategy alone on that particular issue. Despite or as a supplement to his allocution here today, the evidence, some of which the jury saw and some that they did not, establishes an extreme power imbalance between Mr. Victorino, Jerone, and the other teens involved in this crime. Age disparity, again, Mr. Victorino was 28 at the time, Jerone was 18, and Robert and Michael were also, Robert Cannon and Michael Salas were also 18, just months older. Significant size disparity, Mr. Victorino is 6'7". Jerone is 14 inches shorter than him at 5'5", and the two other teens were much shorter too than Mr. Victorino. Even setting aside the power disparity between the size of Mr. Victorino and Mr. Hunter as a teenage boy, the record shows that all three co-defendants and Brandon Graham and even that these were all much younger individuals than Mr. Victorino, and they expressed fear of Mr. Victorino for his violence, erratic nature, and alleged affiliations. And we'll cite the specifics in the sentencing memorandum. You also, of course, have heard the readbacks from Mr. Salas that he feared Mr. Victorino would kill him and his family. He testified to that in 2006. Mr. Salas, of course, refused to testify in this case and actually was held in contempt for not doing so. Brandon Graham testified that he was, and he repeatedly said he was afraid of Mr. Victorino because of his size. And Mr. Victorino said he wanted to kill people and he feared that he, Mr. Graham, would be next. And Mr. Hunter, of course, testified in 2006, and it was replayed for the court in the readback that he feared for his life because Mr. Victorino was angry and constantly speaks about everybody that is against him and was physically intimidated, particularly when Mr. Victorino played with his gun while speaking about people disrespecting him. On the 28th of July, 2004, days before the murder, while Hunter was living with Victorino, Victorino assaulted a man and was arrested for felony battery. We put that into evidence. In the summation for this trial, the state conceded that Mr. Victorino is manipulative. Yes, he's the one who's getting this group together and coming up with the plan. The evidence established there was a related mitigating circumstance that Jerone was under extreme duress and under the substantial domination of another person. And that he not only feared Mr. Victorino, but he also depended on Mr. Victorino for his housing. As the state.
So basically, they're just saying Jerone was scared of Troy, and that's why Jerone just followed along and did whatever Troy said, Victorino said to do, because he was the bigger guy, and because he's the bigger guy, we just do what he says. Okay.
They conceded Mr. Victorino got the boys together and presented this plan. When an adult may have been able to resist these pressures, Jerone could not due to his adolescent state and psychological development. The point of this evidence is not to argue that this court should create a categorical exemption for all 18-year-olds, but the court must strongly consider Jerone's psychological development when making an individualized sentencing determination. If Jerone was just 67 days older when this crime was committed, crimes were committed, he would not be eligible for the death penalty. For that reason, and the other mitigation that we will present in our sentencing argument.
That was a verbal mistake, because he said that if he had been 60 whatever days older, he meant younger, because if he was younger, he'd have been under 18.
If Jerome was just 67 days older when this crime was committed, crimes were committed, he would not be eligible for the death penalty. For that reason, and the other mitigation that we will present in our sentencing argument, have argued, we are certainly asking the court to take mercy and sentence Mr. Hunter to life. We are concerned, I know we've raised this in our chart, about the possibility of racial bias in the case. That certainly, and we'll cite the case law that talks about it in our memo, but when racial bias taints capital trials, courts do everything in their authority to take corrective action. The death penalty itself is disproportionately punishes black men for killing white victims, especially white women. As a result, the law says racial bias can play no role in a capital trial. But here, racism and racial bias likely did play a role in Jerone Hunter's death recommendation.
May I ask, is this a summary or is this your sentencing memorandum?
This is my summary.
Okay.
And we'll have much more because we're going to break down the myths and the statutory and non-statutory in our sentencing memorandum. We'll show in the sentencing memorandum, we'll talk about the racial bias and break that down. We do point out in summation that that there were 4 co-defendants, 2 were black, 2 were non-black. The original trial, the 2 black co-defendants received death sentences, the non-black defendants received life sentences. We'll talk more about that in the racial bias and the impact on this case in our sentencing memorandum. Jerone hadn't even finished high school when his involvement in this murder take place. His brother which he had a close relationship, left the house. He was left with his family. You've heard testimony about the effects that Alicia Jr. leaving the house had on him, the treatment he received from his stepfather, the treatment he received from his natural father. We'll certainly again outline that in our sentencing memorandum. But there is, and we'll break down we had 53 mitigators cited in our summation, and we will emphasize the facts that support the testimony that supports each one of them. This court, again, has the awesome power and authority in deciding whether over the jury's verdict in this case. We would ask not only the court show mercy with regard to overriding the jury's verdict, but we also point, as does Ms. Sammons on behalf of Mr. Victorino, that there was non-unanimity in the verdict from the jury, and we believe our position is that constitutionally and as well as the mitigation allows this court to rightfully sentence Mr. Hunter to 4 life sentences. Thank you for the opportunity.
Yes, sir. Thank you very much. Mr. Donis, did you want to?
Okay, so he wants to get 4 life sentences instead of the death penalty. So in other words, stay in prison until you come out in a pine box.
No, Your Honor, we'll save our argument for the sentencing.
All right, very good. All right, then. So let me ask you this. Anything else we need to address?
Your Honor, I think just incredibly briefly, I'm just going to renew the arguments that I made in the motion to sever, because I feel that presentation, Victorino, intimidating, dominating, all those things, and it's very difficult to have, to feel like I can't respond to that because these are individualized sentencings. So that's Mr. Jerone's mitigation. He absolutely should be putting, or Mr. Hunter's mitigation, he absolutely should put that on. It's not an aggravating factor on Mr. Victorino, but it feels like one. So I'm going to probably respond in great detail in the sentencing memoranda, but I have to renew the motion to sever after that argument.
Absolutely, Ms. Sammons, and I understand your position. I'm going to respectfully deny it, and I expect that you'll cover it very well in your sentencing memorandum. Okay, thank you. All right, so nothing else for today. What I'm going to do is I'm going to direct Michelle, my JA, to get with you all, because I know that there's a date coming up where I'm going to be receiving the sentencing memoranda from all of you. 25th. Right, and so she'll get with you all to coordinate hearing time on the sentencing. I do want to have the opportunity to review those memoranda in depth, and so I'll direct her. When do y'all think, just month-wise, just based on your calendars, because I know some of you have very busy calendars, and if anybody has any vacations coming up.
I'm out of the country 3 weeks in October.
Okay, so October's out.
Oh, sorry, September. September, I'm completely open.
Okay, you're open completely in September.
So am I.
Are you? Okay, and
What month are we talking about?
September?
Yes.
All right, so September it will be. So Michelle's going to have to get a little bit creative, because I believe I've got some trial weeks coming up in September, but I will get with her. Let me ask you this. How much time do you think you all will need? Because I want to make sure you have sufficient time.
I don't think we present anything on the sentencing.
No, that's right. You're right. So you're absolutely correct.
So how much time do you need?
That's correct. All right. So I'm going to get with her, and I'll make sure it's all coordinated, obviously. And let me ask you this with respect to presence at sentencing.
They're required to be present. I think that physical presence is required.
Right. So I'll make sure that Michelle has those transport orders done, and I'll have her coordinate everything.
It's
And
close in time to these sentencing hearings. We can't transport them, because I don't want them sitting here if I don't have to. Because he's
Fair.
closer. They're closer. Well, Mr. Victorino's closer to me in my office.
Okay.
Than I am.
All right.
Union.
All right. I'll do everything I can to accommodate. All right.
And Judge, if the court also reflect that Mr. Hunter is asking me to go back to the DOC.
I will TOT to DOC, and that's done. Okay. All right. Thank you all very much.
Thank you.
All right. All right. Okay. So, just for giggles, we are going to switch to this for a minute, just for something for giggles. It's up. I just wanted a little palate cleanser funny before we head out. So I found this one on TikTok. It's only a minute and 20 or minute long. It was just funny watching dogs. Y'all know me and my puppies.
Peter, stuck inside of your cage. How did you do? What kind of witchcraft?
There is no way I left the house for 1 hour.
Are you dead serious, bro? What the fuck happened? What happened? Look at that couch.
What did you do?
What is going on over here?
What did you do? What did you do?
Oh my God. What is this?
Oh my God.
How proud that puppy looked.
What did you do?
Oh my goodness gracious.
Space heater stuck.
Oh, yeah, I the video and stuff. Yeah, I'd like to see that. Definitely. Yeah, I think I may just do like, I don't have anything set up for Thursday's stream. I might just do a how did we get here with Donna Adelson. Just do a bunch of little short recaps and stuff. Lois, you know me and my dogs. I love watching dog videos. I have another one right here. Hang on. Wait, let me find it. Oh, wait. Oh, no, wait. This was really funny. Hold up. I'm gonna play this one real quick before we head out. I'm gonna head this one. Okay, this one was hilarious as hell. It is 3 minutes. I'm gonna cut it short. I would freak out if I came home to that mess. And let me tell you, I live by a river. Not gonna lie, my floor is cracked. Okay, because I live by a river. We have what's called black gumbo, is the dirt that's out here, and therefore my concrete floor, being I'm 3 blocks from a river with all the water adjustment and stuff, and it gets so dry up on land before we get any rain, and when it gets hot, it separates, and these cracks in our dirt will separate enough where you could break an ankle in it. And what happens is my house was concrete built on foundation, and the ground has cracked and has caused a crack in my living room and kitchen. And Lola, I thought I was going to be smart. I took spray foam, my redneck ways. I took spray foam, that foam sealer stuff, and I sprayed it all in that crack, and then I leveled it out. I thought I was going to be smart, right? Lola's a digger. She dug all that spray foam out and made messes all over my living room and kitchen. So now I have a nice gap in my floor. So I don't know what I'm going to do to fix it, because to level a foundation is outrageous. So anyways, I'll play this baby one really quick. These people are they're like, hey, look at my friend's baby. And these women and men are reacting like, oh, and they're like, oh, no, you're on FaceTime. Be nice.
Oh, what happened to it?
Peggy, she's on FaceTime. Dad, look at Holly's new baby.
It's fucked up. Huh?
Yeah, you
Look
didn't
at my
be.
friend's baby.
Oh my God, it's like a little old man.
I'm on FaceTime. She can see.
Oh, stop it.
Isn't it cute?
What the fuck?
Dad, my
What?
friend is on FaceTime.
Oh, it's so cute. What the fuck? Wow. I've never seen a cuter baby.
My friend had a baby.
You should give the baby.
Yeah. You want to see?
Let me see it, yeah. Show she did stuff for yourself.
Yeah.
Jesus Christ, it's a ugly baby for this.
What? Grandma, she's on the phone. She's on the phone.
Oh my gosh. That's like an ugly little baby.
Okay, it's a baby though, amiga. There.
Is it on now?
The
Did you
face.
press it and hold it?
It's recording. No, a baby. I know.
What does that look like, Master?
Look at that. My friend had a baby.
Are you sure that's a real baby?
Yeah, what do you think?
That's the fattest little baby I've ever seen.
Is it cute?
No.
No.
Are you wait? Give me this. Oh my, the kidneys.
Wait, Nana, so my friend had her baby.
Oh.
You want to see?
Yeah.
Look at how cute it is. Nanny, she's on FaceTime.
What's beautiful? What a beautiful baby. Oh,
And it look, Dion done had his baby. Look.
oh shit. Oh, girl, I can't make it.
Eddie, he on the phone. Say something nice. He on the phone.
You say something.
My friend Jasmine just had her baby.
Oh my God. This FaceTime, Grandma.
Huh?
This FaceTime, she can hear you. I'm just saying that's a big baby.
Mom, mira el bebé de mi amiga.
¿Y por qué le salió tan feo?
Mom, ella te está escuchando.
She said it's ugly.
My friend's baby, she had the baby.
Oh my God.
Did you, baby?
Yeah. Oh.
Had it just earlier today.
Oh, all babies are so.
I say, look at this baby. My friend just had Amy.
Who?
Amy, look at her baby.
Jesus Christ, look at its nose.
Mom, you're on FaceTime.
What? Fuck off.
My friend just had a baby. They wanted to show you a picture. What? They're on the phone. What? What? My friend just had a baby. You see it?
Okay, with that, those few little laughs before we got out of here. I know we got to add a little comedy to our chaos. So with that, I have no idea what we're streaming tomorrow yet. I'll figure it out to make a post. So I want all y'all to have a great evening and enjoy the rest of your evening. And take a moment, touch grass, hug a friend if you can. Spend some time with your fur babies if you got them. Till tomorrow. Peace. Rubber out. Y'all have a great night.